Township of Edison Zoning Board of Adjustment regular meeting of April 18th, 2023 is now in session. Adequate notice of this meeting, as required by the Open Public Meetings Act of 1975, has been provided by the annual notice published in the Home News and Tribune on January 14th, 2023, has been posted in the main lobby of the municipal complex on January 3rd, 2023. Please join me in the Pledge of Allegiance to the flag. Madam Secretary, roll call, please.
Mr. Ayotte?
Here.
Ms. Shaw?
Here.
Mr. Bignell? Here. Mr. O'Bara? Here. Mr. Barone?
Here.
Mr. DeVay?
Here.
Mr. Cerrito?
Here.
Ms. Hernandez-Prince?
Here.
Mr. Chabra?
Here.
Mr. Sadaha?
Here.
Vice Chair O'Gorman?
Here.
Chairman Kumba?
Here. Madam Secretary, do we have minutes for consideration?
We do. Minutes for March 28th, 2023.
Motion to approve. Second.
Motion made and seconded. Roll call, please.
Mr. Barone? For minutes? Approval of minutes?
Approval. Yes.
Ms. Hernandez-Prince?
Yes.
Mr. DeVay?
Yes, please.
Mr. Cerrito?
Yes.
Mr. Chabra?
Yes.
Mr. Sadaha?
Yes.
Vice Chair O'Gorman?
Yes.
And Chairman Kumba?
Yes. All right. Madam Secretary, do we have any resolutions for consideration to be adopted?
We do. Z1, 2023, Mohammed Salih.
Motion to approve. Second.
Motion made and seconded. Roll call, please.
Mr. Barone?
Yes on the motion.
Mr. DeVay?
Yes to the motion.
Mr. Cerrito?
Yes on the motion.
Mr. Sadaha?
Yes on the motion.
Vice Chair O'Gorman?
Yes.
And Chairman Kumba?
Yes.
Next
Next
we have
resolution?
Z2, 2023, Elizabeth Coca and David Lathram.
Motion to approve. Second.
Motion made and seconded. Roll call, please.
Mr. Barone?
Yes.
Ms. Hernandez-Prince?
Yes.
Mr. DeVay?
Yes.
Mr. Cerrito?
Yes.
Mr. Sadaha?
Yes.
Vice Chair O'Gorman?
Yes.
Chairman Kumba?
Yes. Last resolution?
Z3, 2023, Alex Braginski.
Motion to approve. Second.
Motion made and seconded. Roll call, please.
Mr. Barone?
Yes.
Ms. Hernandez-Prince?
Yes.
Mr. DeVay?
Yes, please.
Mr. Cerrito?
Yes.
Mr. Sadaha?
Yes.
Vice Chair O'Gorman?
Yes.
And Chairman Kumba?
Yes. All right. Good evening, ladies and gentlemen. This is a regular meeting of the Township of Edison Zoning Board of Adjustment. The board is composed of Edison Township residents appointed by the Municipal Council who volunteer their time and service to the board. The municipal land use law requires that members successfully complete a land use training course administered by the New Jersey Department of Community Affairs. This board also holds in-house training conducted by our board professionals. The zoning board abides by the provisions of the municipal land use law in addition to our board's bylaws. The zoning board is a quasi-judicial land use board, which differs from the township planning board. Under the municipal land use law, board members are required to be impartial and are not allowed to discuss any case prior to its consideration before the board at a hearing. All applicants will have the opportunity to present their case before the board with the opportunity for board members and board professionals to question the applicant and their witnesses. The conclusion of the applicant's presentation of their case will be opened up to the public. Residents within 200 feet of subject property will be heard, followed by residents from outside of 200 feet. All residents will be sworn in, will provide their name and address, and then will be given 6 minutes to comment on the application being considered without the opportunity for rebuttal. Residents may ask questions of the applicant's professionals, and board professionals. The board requests that these questions are asked prior to any comments being made on the application. Once commentary begins, the resident's timer will begin. The applicant would be allowed for the opportunity for cross-examination of their witnesses. Under the law, the chair is allowed to stop any comments that is repetitive or is an attempt to filibuster the board. Further, the chair is allowed to stop any commentary that is irrelevant to the case or prohibited from the board's consideration. Once the public portion is closed, all public comment is ended unless new testimony is presented by the applicant. Following the closure of the public portion, the applicant will have the right of summation on their application. Following summation, the case will go to the board for a decision. This procedure has been followed by this board and is similar to the procedures followed by boards of adjustment statewide. The municipal land use law requires the board to engage in a balancing act. It is not required to strictly apply township ordinances, zoning plan, or master plan. As a board of adjustment, variances are granted when appropriately necessary, following all legal considerations. As has been the case with prior boards, this board will see where we are if we are in session around 10:30 p.m. I ask that the applicants, professionals, and residents show respect to each other and be civil throughout all proceedings. I ask that you withhold applause, booing, or interrupting of anyone while they are speaking. One announcement, case Z3 2021 401 Division Street LLC has been carried. The applicant requests to be carried to May 23rd, 2023. If you are here for case Z3 2021 401 Division Street LLC at 401 Division Street in Edison, that case will be carried until then. There will be no renotice. This is your notice. With that, Madam Secretary, first case on the agenda.
Carried from March 28, 2023 for summation and a vote with no renotice required is case number Z28, 2022, Quick Check Corporation, 425 to 431 Plainfield Ave, Edison, New Jersey, 08817. Section 37-20, applicant is seeking bulk and use variances along with the preliminary and final site plan approval to demolish the existing structures and replace with the fuel station and convenience store. Standards have not been met in accordance with the master plan. Affected property is located in the PB zone designated as block number 4.A, lot numbers 24 and 25 on the Edison Township tax map. All noticing paperwork is in order.
Good evening, council.
Thank you very much, Mr. Chairman, members of the board. I'm Henry Kent Smith. I'm with the firm of Fox Rothschild. I'm representing Quick Check tonight. And I appreciate the board providing us the opportunity to provide a brief summation before the board makes its consideration and vote on this application. We've had 4 hearings, and this is the 5th time we've presented before this board. So there's been a lot of testimony presented. We've had both our client, Mr. Lamont, as well as a professional site plan engineer, a professional traffic engineer, our project architect, and a professional planner all testify in support of the proofs required for this board to consider and grant the requested use variance relief. Singularly put, we do
Mr. Ken Smith, I'm sorry to interrupt you. Can you bring the microphone a little closer? Thank you so much, sir.
You bet. Simply put, we believe we've met all the criteria under the statute. And as part of my summation, I do want to just go through a couple of the exhibits that we presented early on at this proceeding. These exhibits lay the foundation for the relief that we're requesting from the board tonight. The first exhibit was the first exhibit that we showed. This was marked A1 at the first hearing on October the 25th. And this is an aerial of the subject property. I just want to highlight several critical factors as to the condition of the property and why we believe the Quick Check application is particularly suited for this piece of property. First and foremost is the property is over 90% impervious coverage. It is fully paved out. On this property, there are 3 uses: the Stelton Diner, the B&L Tire, and then the former Pepper Market. Now, the Pepper Market's no longer in business, so this building is no longer being occupied. In addition, this property is 2 acres total. That's the yellow line around the photographs. But there's actually 2 lots. Lot 24 is an L-shaped lot, and lot 25 is where the tire store is. So this property, as Mr. Kunzman testified originally, is not in conformity with your ordinances. The property has too much impervious coverage, it doesn't meet setbacks, and more importantly, there are 2 aspects of the property that are non-conforming uses. One of which is that over the Stelton Diner, there are some apartments, which is not a permitted use in the PV zone. Secondly, the B&L Tire is, in my humble opinion, not a permitted use in the zone either. So the application then involves taking a property that's, quite frankly, at the end of its useful life. By that I mean these are buildings that are very old. They have been around for decades. There are uses that have been here for decades. We acknowledge that. But they are also nearing the end of their use life. Now, that's evidenced by the fact that I'm standing in front of you. The property owner has put this property on the market. The property owner is looking for a new owner. They want to sell the land and bring in a new use. This happens, and it's actually a good thing. It's how progress occurs relative to repositioning properties, eliminating certain nonconformities. One of the nonconformities is that right now on Plainfield, you have 1, 2, 3, 4 different driveways that are serving these uses. And they all have curb cuts, and they don't conform with the county standards. So part of what we are proposing with the quick check will help eliminate a lot of these existing non-conforming conditions. Now, as I said before, the property is on the market, so it's not like these uses are going to stay here forever. Something is going to happen, whether it's this application or another. So I submit to the board that what we are proposing, and I'm now going to start referring to Exhibit A4. This is the engineer's exhibit, Mr. Kunzman, also dated October 25th. This Exhibit A4 shows what Quick Check is proposing and how our proposal will rectify many of the existing nonconformities, as well as provide some real benefits relative to things such as the visual and aesthetics of the property. So as Mr. Kunzman testified to, we're going from over 90% impervious coverage on a, as he said, an unregulated stormwater. In other words, the stormwater, it rains, it just goes where it goes. Versus with this quick check, Mr. Kunzman testified in detail, and Mr. Carley's office reviewed it, we're going to have a formal stormwater management plan. Now, one of the concerns that we heard related to stormwater, we acknowledge, and this will make stormwater better. It'll make it better because it has less impervious coverage and a formal stormwater management system. Now, with the elimination of these nonconformities, it also allows Quick Check to do some real positives. There's an extensive landscaping plan. It will have a single point of access at this traffic signal, and then just a right-in only on Plainfield to enter the site before you get to the traffic light. So as Mr. Kunzman explained, this is a very efficient layout. It's a very efficient circulation system. And this proposed plan has been reviewed by Mr. Bignell and Mr. Carley's office. We've gone through reports, we've made plan revisions, we've made resubmissions. All of these are to the point where we are in compliance with or will agree to comply with any final recommendations from either Mr. Bignell or Mr. Carley's office. Therefore, we have done the best possible to make sure that the design before this board meets this township's design standards. Thank you, Mr. Chairman. I'm going to take a seat. It's just easier to talk when I'm sitting. So we have also proposed, as part of this application, a traffic analysis that demonstrates that, as Mr. Korak testified to, this quick check is a very appropriate use on a heavily traveled roadway. Why is that? Because a quick check with a fuel service feeds or exists off the existing traffic flow. People drive by and go, oh gosh, I need gas. Whoop, there's a quick check, I'm going in. Or geez, I haven't gotten my coffee and I gotta get to the train. There's a quick check, I can grab my coffee, get to the train and make it on time. That's what Quick Check does. That's what Mr. Lamont testified to with a lot of why this location. Now, the first element of this is obviously we want to make sure it works from a traffic circulation and traffic perspective. So Mr. Korak's analysis showed that it does. Based on the fact that it's 75%, as Mr. Korak testified to, 75% of the cars on the road are already on the road, and that only there are 25% of new cars coming into this area as a result of the quick check, the total traffic impact is less than a lot of your permitted uses. That's what Mr. Korak demonstrated when he was before the board in December. The impact of that on the traffic light itself means the traffic light will still function as it was designed to at the levels of service that it is supposed to meet. And that as a result of that, the traffic impact of this proposal is compatible with this location. It's compatible with the design of the current traffic light, and it's compatible with the overall flow of traffic. Now, Mr. Lamont also explained that the fact that this is a busy area, and we acknowledge that, is why we're looking to locate on this property. It's because there are a lot of people who are moving towards the train station for commuting purposes or are coming back home, or there's a lot of residents in the area. All of these show that this type of use would have a very successful ability to use that existing traffic stream in order to keep folks busy, and keep folks moving on the roadway. Because again, the whole design of the convenience of a quick check is a one-stop shop. You need something like gas and you want to get coffee, you can do it all in one shot. There were comments from neighbors and the public about, well, we already have a convenience store here. We already have a gas station there. When you combine these two uses, that's a benefit. Now, this is a use variance. The principles governing the grant of a use variance have been established by our courts for years. The first case, Medici, was decided in 1986. And then most recently, the Supreme Court in a case called Price versus Hemingway in 2013 revisited and really amplified certain of the standards that are required to be met in order to grant the requested use variance. Now, the standards as established under Price versus Hemingway are critical because what the Supreme Court did is to say, you look at the totality of the application that's before the board. You don't just look at one thing, you look at the entire proposal. And what you focus on is the property and its particular suitability. That's actually the term the court used, the particular suitability of the property for the proposed use. And then you look at two elements of that use, its positive impacts, the special reasons, and its negative impacts, which are the negative criteria. So we have presented the testimony of Ms. Nazara Kafone as our professional planner who walked through in great detail these proofs. And since that's really at the core of what this board has to decide, I just want to summarize what her testimony was, what the findings are, and why they are compelling, in my opinion, in support of the grant of the requested relief. So the first aspect of this is that the property is particularly suitable for a number of reasons. And she went through in some detail both the prior testimony and the applicant and the application itself. And first and foremost was that there are existing nonconforming uses and that this property is prime for, and she kept saying, small r redevelopment, i.e. not redevelopment formalized under the redevelopment statute, but just a property suitable to be repositioned in the market or redeveloped. And that makes the property suitable because it's reuse of property. It's not taking green space, it's taking property that's already in existence and that's coming to an end of its market life. And that is an important criteria that makes the property particularly suitable for a variance relief. It also has a number of characteristics that Mr. Lamont testified to that are necessary for quick check and positive for that location, as well as a size at 2 acres that is also very important in terms of being able to design the quick check to meet the design standards of this township for this type of use. So first, the replication of the the location next to the Northeast Corridor train station is a positive. Convenience stores and fuel service, you get off the train and you go, gosh, I need gas immediately because I barely had enough to make it to the train and I was late and I had to park. We're right here. As I've got to go north on Plainfield. Where am I going to get gas? Here we are now. So that's the type of convenience that QuickCheck utilizes and thrives on. And in some respects, it's very supportive of a transit-oriented development. It works well with the mass transit. The other aspect is the area or neighborhood in which this proposal on the property is located. This is a mixed area in the township. By that I mean, if you go down Kilmer to the west, you're hitting a large industrial area. So there's a lot of daytime employees, a lot of workers there. To the east and north behind us, there's residential. We are immediately surrounded by an office. So this mix of use is precisely what QuickCheck is designed to satisfy. We provide lunch for people who are working in the industrial areas and in the office buildings. We also provide convenience supplies and fuel for the residents in the area. So that mixed use is something that makes this particular piece of property very attractive for this type of use and very well suited for this type of use. But it also does something more, which is when you look at the property and the proposed use, you got to evaluate, how does this all fit together? How does the use fit on the property? So in your ordinances, in the GB General Business Zone, you have convenience store with fuel service as a permitted use. And there are standards associated with that particular use. Mr. Bignell, in his last report, went through in detail. Okay, if this was in the GB zone, would we meet all the criteria to develop this property without a variance? And the answer is yes. That in and of itself is clearly proof that it's an appropriate fit for this use on this property. Because all you had to do is zone it GB and we wouldn't be in front of you. We would in fact be an as of right permitted use before the planning board. However, the GB zone boundary did not make it down to this particular property. Rather, it stopped where the Lidl property was approved recently. So with regard to the appropriateness, the fit of this use on the property, quite frankly, I haven't encountered many properties where it fits better. And this is something Mr. Lamont testified to right up front, that this is what attracted him to this property. It was rectangular, it had a traffic signal, it met all the criteria for what QuickCheck is looking for when it's looking to develop a property. Now, this particular suitability doesn't stand in and of itself. We also have to show, why should the board grant a variance? What purposes of zoning and land use are being furthered by this application? And Ms. Gaffone testified. There's four, she actually testified to four, but I'm going to highlight three of the criteria that she cited to support the grant of the variance. Criteria A, and by the way, as she said, the criteria are found in Section 2 of the Municipal Land Use Law. So 2A says that you want an efficient and a use of land that is efficient and works within the comprehensive plan, and this property does. Why? Because it combines two separate uses, retail, which would be an as-of-right use by itself. In other words, this very zone would allow the retail convenience store, just not the fuel service. But when you combine the fuel service with the retail, when you put them together, it's much more efficient. Why? If I need gas and I need coffee, I can go to one place, QuickCheck. If I need gas and I need coffee and I don't have a QuickCheck, I got to go to the Dunkin' Donuts or wherever, and then I've got to go to the gas station. I've got two trips. Now I'm back out on the road versus a one-stop shop. So in her opinion, that met criteria A. Now, the second criteria, criteria C, is does this use and is the proposed development properly accommodated in the property? And as I've said before, it clearly is. Within the 2 acres, we can fit this use beautifully within context of the bulk standards for this use in the GB zone. And finally, criteria I, which is a desired visual environment. Ms. Gaffone stated that this definitely meets criteria I. Why? Because the existing property is, quite frankly, at the end of its market use life. That's why it's on the market. What we are proposing with the reduction in the impervious coverage, with the formalized landscaping plan that we have, will make and significantly enhance this rather highly visible parcel in the township. And that by meeting these criteria, and you only need to meet one to justify the grant of the variance, but in meeting these criteria, we believe, and Ms. Caffone's opinion was, this meets all of the necessary proofs to establish why the board, on a positive basis, should grant the requested relief. Now, she also observed a couple other aspects of this. One is there are 2 existing lots right now, as I pointed out originally and shown on A1, that are going to be consolidated. So I'm actually reducing a non-conforming condition by consolidating the lots. The second aspect of this is that the property in and of itself it's going to be repositioned. It literally is at the end of its use life. And land use wants to see reuse of land, not necessarily taking green space and paving paradise to put up a parking lot, but rather take a parking lot and make it smaller and more efficient and work better. So once you establish the positive criteria, there's another element of the proofs that have to be met, and that's, well, why is this use variance? Why is this proposal before this board? How can that be harmonized with the master plan and the zoning ordinances in terms of the fact that it's not permitted on this property? And Ms. Caffone discussed at some length about the fact that the use is actually more conforming, relatively speaking, than the existing nonconformities. So you're helping get it closer to master plan compliance by eliminating pre-existing nonconforming uses, by modernizing the property and eliminating bulk nonconformities on the existing property. And then she's talked about the master plan's economic development goals. And the master plan has clear economic development goals that balance the competing interest of redevelopment and development with traffic. And we've heard a lot about traffic, but this particular development balances those 2 elements very well. The master plan objective to further economic development with traffic, and that's because we live off the existing traffic. We're not like a use that's going to put a lot of new cars onto the road. Rather, we're going to use the traffic that is on the road already to come to our property to then conduct our business, either buying fuel or other sundries. So in her opinion, Ms. Nazara Caffone was clear that she believed this furthered the economic development condition. And I just want to point out Mr. Lamont's testimony at the beginning of this proceeding, which is that this proposal is going to create 30 to 50 new jobs in the community, and that those jobs are far in excess of the employment being created by this property under its present condition. And so I believe the fulfillment and furtherance of the economic development elements of this master plan would justify and reconcile the grant of the master plan, the grant of the variance for this property. Now, what's the last test? It's the negative criteria. What are the detrimental impacts if this board were to grant this relief? Now, the negative criteria have 2 parts to it. What is the impact going to be on the neighborhood? And again, while I acknowledge a lot of the concerns that were raised by the residents on the negative criteria, there's certain things that this board, I did not have the opportunity during the direct yesterday at the last meeting, but I want to make sure the board's aware of as part of their consideration. There was a lot of discussion about the daycare facility. There is simply no regulation that prohibits the location of a convenience store with fuel service next to a daycare center. Not in this town. There's just no standard that would be applicable. But more importantly, the municipal land use law, which, Mr. Chairman, you acknowledged in your reading, that's what governs this board. The municipal land use law has a specific provision that relates to daycare facilities, and I'm just going to quote it. This is from NJSA 40:55D-66.6 of the municipal land use law, and it simply states, child care centers that require state licensure, and that's a summation of that, shall be a permitted use in all non-residential districts of a municipality. So what does that mean on this application? If a daycare center wanted to build right next door to our property, they are a statutorily permitted use. Whether or not they're permitted in the zone, the statute, the MLUL says, you're permitted because you're in a non-residential zone. So here you've got the state on the MLUL saying that daycares can be in non-residential zones. And what's missing? Nothing about, except for when you're next to a fuel or a gas station, except when you're next to this or that or the other. It's simply, you're permitted in a non-residential zone. And I think that's something critical to consider, that there isn't a spacing standard. And the reason is that we have, I think, probably with California, the most stringent environmental protection laws in this country. Those laws are particularly stringent as it relates to the use and disposal of hazardous substances, fuel being one of them. And they require all sorts of different protections in order to properly operate within the NJDEP requirements for this type of use. These regulations, I understand the daycare is concerned, but quite frankly, QuickCheck is concerned for their employees. They're concerned for their customers. They don't want to have a toxic situation on their property where people are visiting. And they don't. And the reason they don't is that we do comply with all the DEP standards and requirements for the dispensing of fuel, both its storage and its dispensing. So with regard to the concerns of the daycare facility, I just submit that this use is not going to cause a bigger problem. In fact, this use may even help the situation because, as was discussed during resident comment, part of the redevelopment of this site will be the remediation of existing environmental conditions that may exist on the property so that it comes in full compliance with DEP standards. So with that, I just want to conclude with a couple of things that QuickCheck has agreed to, and recognition that it's appropriate for this board to impose conditions on a use variance application where the applicant needs to address certain concerns. Now, there are residents who live over the Stelton Diner. Apparently, they are actually tenants of the Stelton Diner. But my client and the property owner and the Stelton Diner will follow all required New Jersey protections under landlord-tenant law to assure that the residents are relocated in conformity with the statute. And that use, again, pre-existing non-conforming use that's not supposed to be here, we will make sure that the residents in that location will be relocated in accordance with the New Jersey landlord-tenant law. A couple other conditions that were raised by the board. We've agreed we'll use the automatic door closure on the dumpster so to make sure the doors stay closed so that doesn't happen. And we've said on numerous occasions through our witnesses that we will agree to enforce a no truck fueling prohibition. We'll do it by signage and we'll do it through our employees, both have been testified to, so that we think in following and imposing those conditions, any concerns the board may have relative to negative impacts can be addressed as part of this application. So in conclusion, Mr. Chairman, I greatly appreciate this board's time and consideration. This has been a long application. There's been a lot of testimony. It's been a lot of public interest. But I want to thank the board for its careful consideration of this application. We believe the time is ripe for the repositioning of the property. We believe that this is a very appropriate use for this location. And we believe that in allowing this use to move forward, it will ultimately inure to the benefit not just of the township, but also of our local community. And I can just see the number of people who will be stopping by QuickCheck after dropping their kids off at the daycare center to get their coffee or get their gas in their car so they can make it to the train station. Because that's what we do. That's how QuickCheck stays in business. So with that said, Mr. Chairman, I conclude my summation remarks, and I thank the board for its time and attention.
Thank you very much, Council. We appreciate that. With that, I will go to the board.
Mr. Chair,
Mr. Dave?
I would like to make a motion to approve the retail store, convenience store use at this proposed site and deny the gas station use at this proposed site. Now, I don't know, the board would like to vote on two separate motions, or you can vote on one motion?
I'm going to turn to our counsel.
I think it's best you probably bifurcate it and just do two separate motions, but that might be the easiest to get a vote and understand where everyone stands.
All right, so I would propose to make a two separate motion. One motion would be the motion A to approve the retail store, convenience store at this location. And motion B would be to deny the gas station use at this proposed location. Now, I just want to be, board member to be careful when the second motion is to deny the application. It means that if you agree with it, you have to vote yes and not the no. And reason for making these two separate motions are this being a PB zone, retail stores are permitted use in this zone, and gasoline station with convenience store is not a permitted or a conditional in this zone. There are simply too many bulk variations with this application. Application has failed to demonstrate that proposed gas station use is good for the general welfare of the public at large. Proposed gas station is close to 200 feet or less from the Montessori Day School, children's school, where 2.5 to 13-year-old kids are attending that school. In spite of positive traffic study, I believe that there will be a traffic congestion at the underpass at the Kilmer Road and the new signal new signal at the Kilmer Road junction. Applicant has failed to demonstrate that the proposed gas station is necessary due to any kind of hardship. That's it.
Rachel, when you do this, I think you're going to do one motion at a time. So let's first take a vote on the first motion.
There was a motion, but we would need a
still.
second.
So just on the first motion, we need a second first. So motion to approve, if I understand it, the retail store, which is in the PB zone, is the first motion. You're going to need a second.
I second.
Madam Chair, Mr. Chair,
Mr. McDowell.
and this is a legal question. If you separate the activity, the retail store, I think, is permitted use in the zone.
Yes.
It is permitted
Don't
use.
you lose your jurisdiction at that point
I
as a
think you
board?
do.
I-
Mr. Kent Smith, I think you do lose jurisdiction. I think for purposes of this application, though, would you want them to still vote just to continue the process? Because I don't know how you're going to want to handle this.
Again, I think Mr. McNeil's 100% correct. If the issue is the convenience store, it is already a permitted use, and therefore that's planning board matter. I don't know how the board could vote except by reverse. By that I mean what's not permitted is the fuel service.
So you want the second motion heard first?
I
Okay.
believe that would be, quite frankly, dispositive of the issue relative to
okay.
what is in front of the board.
Okay, so we're doing the second motion first. Motion to deny at this location the gas station. And just to repeat it, it's because you indicated it was not permitted, the bulk variations are too many, not good for general welfare, close to the daycare, traffic congestion, and that the applicant failed to demonstrate that the gas station is necessary due to any hardships, correct? Okay, so now we need a second on that motion.
Second.
Motion made and seconded. Madam Secretary, roll call, please.
Okay, so for B, to deny the gas use, Mr. Barone,
No on the motion.
Ms. Hernandez-Prince,
Yes on the motion.
Mr. DeVay,
Yes on the motion.
Mr. Cerrito,
Yes on the motion.
Mr. Chabra,
Yes to the motion.
Mr. Sadaha,
Yes on the motion.
Vice Chair O'Gorman,
Yes on the motion.
and Chairman Kumba.
No on the motion.
Mr. Chairman, again, because the use of the convenience store is a permitted as of right use, I don't think the board has the authority under the municipal land use law to take a vote relative to the C-store aspect of this. I defer to the,
I'm going to defer to the council, and
I
I'm
tend
also
to-
not going to step on the toes of my good friend, the chairman of the planning board.
yes, understood.
I tend to agree with you. I think the motion to deny is your answer.
I agree.
Okay.
So, again, thank you very much for your time and consideration. Greatly appreciate your attention to this. Thank you.
Thank you very much. And with that, this application is denied. All right, ladies and gentlemen, we are still in session. We are still in session. All right. Next case on the agenda, please.
Carried from January with no renotice required, case number Z24, 2022, Old Post Realty LLC, 604 and 610 Old Post Road, Edison, New Jersey, 08817. Preliminary and final site plan approval is being sought along with a use and bulk variance to construct a 210.
Folks, I'm sorry. If you could please, we are still conducting business. Thank you. Raise your hand and continue.
Thank you. Variances to construct a 210-spot parking lot for car dealerships. Standards have not been met in accordance with the master plan. Affected property is located in the LR and RB zone designated as block number 48.02 and lot number 266 on the Edison Township tax map. All noticing paperwork is in order.
All right, we'll just give a minute for council to approach.
Good evening, Mr. Chair, members of the board, professionals and staff. Peter Licata of the law firm of Sonnenblick, Mayer and Licata on behalf of the applicant. Thank you for inviting us back tonight. If you would indulge us, based on the input we received from the board and its professionals at the last meeting, we did make some revisions to the plan that we would like to lay out for you.
Okay. All right. Thank you, officer. Thank you so much. Folks, if we just get quiet in the chamber so that everyone can hear the presentation. Thank you.
Thank you, Mr. Chair. Mr. Lane is our professional engineer and project engineer. He was previously sworn. I suppose you'd want to swear him in again tonight.
Sir, would you
Bill,
raise your right hand? Do you
and stand
solemnly
up.
swear or affirm to tell the whole truth and nothing but the truth, so help you God?
Yes.
And just bring the microphone nice and close. Thank you. And
Yes.
State your full name for the record.
William Lane, Lane.
And Mr. Lane, you were previously accepted. Your license are still current and in good standing?
Yes.
Okay, thank you. You may proceed.
Thank you, Mr. Chairman. We did have the image up a moment ago, and I can see Mr. Takina behind me trying to bring it back up for you. It looks like it may just about, there it is. Bill, in a brief narrative fashion, could you explain what changes have been made since we were last here?
Yeah, on the westerly property line, we moved the proposed fence in another 10 feet, so it's 16 feet off the property line, setting the fence approximately 80 feet off the neighboring home. That allows us to put the landscaping buffer on the neighbor's side of the fence before they see the fence. And with that, we've got about 81 evergreen trees. At planting height, they'll be 8 feet high, and then another 15 deciduous trees that'll sit on the, like I said, the neighboring side of that fence. Our next change was for the lighting. We reduced the light poles down from 17 and a half feet. That was on the last set submitted to this set. They're 12 and a half feet high. And when we reduced them, we revised the LED wattage from 164 down to 63 so we could help with not having any hot spots on the pavement. Next was the Old Post Road gate at the entry along the westerly side. That got moved back to 33 feet off the right-of-way line and approximately 44 feet off the edge of pavement. And the gate itself had gotten reduced down to 18 feet. Additionally, we revised the portion of the pavement. Approximately 18.7% of that pavement area is now porous pavement. So the other, the remaining portion of the site.
Mr. Lane, I'm just going to interrupt you for 1 second. Can you just bring the microphone closer to you?
Yep.
Thank you so much.
Sorry. So the porous pavement is now 18.7% of the impervious coverage on site. The remaining site impervious coverage is 50%. So with that, we have a all-inclusive impervious coverage of 68.7, which is slightly reduced from the 70% we originally had on the plan.
And that's before taking credit for the porous pavement of how many percent?
18.7% is approximately 24,000 square feet.
Okay. So the pavement which is completely impervious, how much of what percentage of the lot consists of pavement or other surface that is completely impervious?
50% of that.
50%.
Correct.
Thank you. Also, when we were last here, I think the board engineer asked you to look into seasonal high water table data. Did you happen to do that?
Yeah, we've had soils testing done, which was utilized in our stormwater design. And all the test pits that were in where the detention basin is and our infiltration area, everything ranged from 10 feet down to 15 feet with no seasonal high, no modeling. It was all the way dry down to there.
Thank you. And lastly, from my point of view, Bill, at this point in time, do you have an update for us on our applications to the NJDEP?
Yeah, the beginning of February received our NJDEP LOI presence absence, so it says there's no wetlands on the site. And we're currently going through the process still with getting our flood hazard and general permit out to the stream.
Thank you, Bill. Mr. Chairman, at this point, I'd make this witness available to the board's professionals for questions.
Okay. Mr. O'Barrow?
Thank you, Mr. Chairman. In reviewing the plans and Mr. Carley's review letter, it appears that the applicant has either agreed to either address the conditions or agreed to address any of the remaining comments in the review letter, if my understanding is correct. So I don't have any further comments at this time.
Okay. Thank you. Mr. Pino?
Mr. Chairman, I believe that the applicant agreed to our comments in prior hearings, so unless that's changed this evening.
No change, Mr. Chairman.
Okay. Thank you very much.
Thank you, Mr. Chairman. If there are any questions from the board for this witness, otherwise, that's again my affirmative case.
Okay. Does the board have any questions, Mr. Lane?
Mr. Chairman?
Vice Chairman?
So the initial application had proposed 70% impervious, and now it's 50?
No, it's 68.7, with 50% being solid impervious and 18.7% being porous pavement. So the water can trickle through the porous pavement into the underground.
Okay. And then also with the lights, you're going to have the covers on them?
Yes.
And they're only going to be used for security?
Correct.
All right. The other item is that gate on Old Post Road. That gate will be locked and only be used if you cannot use the right-of-way of public service?
Correct.
That would be a condition if this got approved.
Yes, we'd stipulate to the condition. I think the only other exception would be emergency vehicle access.
Correct.
Yes.
All right. Thank you.
And then just for the record, for emergency vehicle access, that would be secured with a Knox box?
We would stipulate to that and consent to it as a condition of approval, certainly.
Okay. Thank you. All right, anyone further? Mr. Chhabra?
Just to confirm, so the east side, you have a 18-foot emergency access with the Knox box.
Correct.
So the existing entrance that's in the in the south of the site, which you guys moved to with an 18-foot gate, is the curb the same? The radius of the curb from the right-of-way?
On the new driveway?
Yeah, the new drive lane, that's going to be one-way access, I believe. Is that correct?
Yes. Well, you can go in and out.
Okay, but is the
pavement shown is 24 feet, which is a typical two-way driveway.
Okay, but was discussed that it'll be one-way or two-way? This was only going to be used for emergencies, right?
Well, they have to go in and then be able to come out.
So the flow of traffic for these vehicles are going to be coming in from here or Route 1?
Would you revisit the PSE&G access way entrance?
Yeah. Everything that's going to be taken from this lot and utilized and shown in the Route 1 facility will come out the rear of the property across the PSE&G easement where Katina has an agreement, and then into the backside of those, into the backside of the dealerships.
So where's the inflow of the vehicles from Route 1?
They'll be dropped off Let me start over again. They get dropped off in their prep center over at Raritan Center.
I understand that.
They get detailed up, they get driven over, they get brought to the dealership, they get logged in, and then they get driven into the storage lot.
So when you were saying it enters the dealership, is it entering from Route 1 or Old Post?
Yes, Route 1.
Route 1, okay. So it's entering from Route 1, and the entrance, that's 18-foot gate. Sorry, it's the 18-foot gate with the 24 feet drive aisle. What's the purpose for that exit?
Well, the 18-foot gate is for any kind of emergencies or when we're not able to utilize the PSE&G easement that they can go out that entryway.
I mean,
And the 24-foot aisle is just a standard driveway for a two-way traffic.
So there's 2 gates on Old Post Road, just to confirm.
Well, there's the gate on the new driveway that's being just utilized for this inventory lot. Then there's an emergency gate on the southerly side where that's just being utilized actually for the home, or if emergency needs to be come down on the southern side of the property.
Correct, so that lower gate, that's the emergency gate with the Knox bus.
That'll just purely be locked for any kind of emergencies.
Okay, and the one on top of that, which would fall on the south side, the property.
Along the west side along Old Post Road, up
Correct.
the new one, yes.
That's the new one.
Yeah.
So that's going to be what directional traffic?
It's going to be a two-way driveway because if you, like I said, as if an emergency vehicle comes in or a car comes in, they have to be able to circulate back out any kind of fire vehicle or any kind of emergency vehicle.
And Bill, as the applicant has testified before, are they going to use the Old Post access for the movement of inventory vehicles to and from this parking lot?
So, month ago,
Can I just
Wait,
finish
sure.
and ask him the question? In what circumstances would the applicant use the Old Post Road access to move inventory?
If public service had to temporarily shut down the easement,
Okay.
then they would have to use the Old Post Road entrance.
Correct. And is that the only use it would make as a stipulated condition of approval?
Yes.
Thank you.
So during the normal times that you have the right-of-way from the easement, this entrance would not be used, neither entrance from Old Post Road.
Correct.
So would it be acceptable for this to be a one-way road and make the gate smaller? Because the drive aisle is 24 foot. The radius off the right-of-way is still the same.
Well, you still need to get a fire truck into the site. And once the fire truck comes in, he's going to have to turn around and go back out.
That's the lower
No,
emergency exit, right?
it's just this one because that one's only if there's something on the southerly side.
I mean, it's one site.
So you have 2 emergency accesses, one which is basically to the east, right?
Right.
Okay, and that is on the east side of the block building, the rectangular building, which is shown on the plan?
Correct.
Okay. And then you have another access that would be emergency accessible for the parking area itself.
Correct.
So in the event of emergency on either side of this 3-acre property, fire trucks could traverse into the depth of the lot, either on its east side or its west side. Is that correct?
Correct.
Okay.
Okay, so the top entrance is also going to be used as an emergency.
Correct.
Okay. So will there be any signage on the gate saying that this is fire use only or such?
We could add signage, but there's nothing proposed at the moment.
Okay. All right. Thank you.
Thank you, Mr. Chaba. Mr. Dave?
So if I heard the testimony right in last meeting, the Old Post Road, the 24-foot gate, you agree to reduce it to 18-foot for emergency use only.
Correct.
And that's what we are still doing it.
Yes.
No 24-foot gate, 18-foot gate.
18-foot gate, correct.
Okay. All right, thanks.
Okay. Any other questions?
Was it 14 foot or 18 foot last time? 18 foot? Okay. I just recall that I remember that we mentioned there would be one-way traffic. Is that correct?
I think I heard the testimony correct. You need 18-foot for emergency vehicles.
Correct.
Okay.
Bill, did you discuss the reduced 18-foot gate width with the fire chief since we were here last?
Yes, I spoke I believe it was the 14th with Fire Chief Toth, and we discussed the width of the gate.
And was he satisfied with an 18-foot width as being the narrowest feasible and acceptable width for his purposes?
Yes.
Thank you.
Okay. Mr. Dubey, Ms. Schaub, are you done? Okay. Ms. Dubey? Okay. Any other questions from the board? Okay.
Thank you, Mr. Chairman.
All right. All right, Mr. Claudia, you're done with your direct case?
That is correct.
Okay. All right, thank you. Excuse me? You can stay up there.
Oh, okay.
Yeah. Okay. All right, so we're going to take a 5-minute recess just so that we could switch out presentations. My understanding that the Residents' Council also wants to plug in, so we'll take 5 minutes so that we can do so. It's 7:56. We'll gavel back in at 8:01. Thank you. We're currently adjourned right now, so you can do that when we get back on the public session. All right, ladies and gentlemen, we are going to return to session. If you are having any conversations within the chamber, please take your conversations outside the chamber so that the board may continue to conduct business. So with the conclusion of Mr. Licato's direct presentation, we'll now go out to the public. All residents within 200 feet of the subject site will be heard first, followed by residents outside of 200 feet of the site. All residents will have up to 6 minutes for any commentary. You are allowed to ask questions of the applicant and their professionals. Any questions will be done at the beginning of your presentation, and they will not count towards your commentary time. If at any point that a question turns into a comment, you're asking a question, you say, well, I don't agree with that, or you say something under your breath, I don't agree, your timer will automatically begin, and the chair will make you aware of that. So with that, is there anyone within 200 feet of the subject property that would want to be heard?
Mr. Chairman, my name is Brian Schwartz. As you know, I'm the attorney for Robert Szilagyi and Mary Briguer, both of whom border the subject property. I'm representing them and only them, so I'm sure that there's other people within 200 feet who will be interested in questioning the witnesses as well.
Okay, Mr. Schwartz, if you could please identify your clients.
Mary Briguer and Robert Szilagyi.
Okay, folks, if you just approach, I just have a question for you. If you can just approach the podium. Yes.
I'm going to ask both of you to raise your right hand. Do you solemnly swear or affirm to tell the whole truth, nothing but the truth, so help you God? Okay, and if you could just lean into the microphone one at a time and state your full name for the record, along with your address.
Mary Brugger, 600 Old Post Road, Edison.
Robert Szilagyi, 614 Old Post Road.
Okay, and each of you understand that since you have retained counsel, you effectively, the counsel will speak for you. You will not have an opportunity during public commentary to ask questions or comment.
They will testify.
I'm sorry, I'm asking a question to them, not to you, counsel.
Well, they asked a question I think they can't answer because they are going to testify.
They're
They'll
not-
ask questions and then they will testify. When it's appropriate for them to testify.
It's as part of your case.
Yes.
Okay, approach the microphone when you answer me.
Yes.
Thank you. Okay, and then also, counsel, you have a seat right there if you'd like to utilize that.
I don't need to use that because I'm going to be asking questions about the plans.
Okay, everyone's going to have to be on microphones, just so you know.
Well, right now, I'm going to ask the question, so they can sit down.
Okay.
All right.
Then you can proceed.
Okay, does the applicant have all his witnesses here?
Mr. Licata.
Yes, we do, sir.
Okay, well, since the engineers testified tonight, I'd like to ask questions of the engineer first.
Mr. Lane, would you join us back at the table?
All right, Mr. Lane, I remind you, you're still under oath.
Okay, thank you.
Thank you.
Could we see that latest plan that was submitted since the last hearing? Could we see that up on the board?
Mr. Chair, he would have to log out. We'd have to log back in.
Yeah, we took the 5-minute recess to allow you to log in.
Yes, sir. And I said I wanted to inquire of the witnesses on their plans first. If somebody wants to show me how to log out, I'll be happy to do so.
Yeah, Mr. Licata, do you have a hard copy of the plans?
Bill, do you have a hard copy? Maybe you could share with
I have an 11 by 17.
with Mr. Schwartz. Why don't you take your notes off there on the sticky and hand that paper copy of what was just up on the screen to Mr. Schwartz.
I'm not sure what I did.
You have to be on a
whether it's
microphone.
Necessary or not.
And I see our planner is working to log back in with the plan overhead. There it is.
There you go. Good. Thank you. Thank you, Mr. Lane. Mr. Lane, when did you submit these plans?
I believe that was end of January, beginning of February.
Okay, all right. Because no one ever told me that there was revised plans submitted. I would have thought it courtesy since I've been involved in this application that somebody would tell me. But in any event, so what you testified to, Mr. Lane, was the only changes, which I understood as to be The border along the property line was 604, I assume? That's one, is that correct?
Oh, Mary's property, 600?
604. I'm sorry, 600, yes. That's where you're adding trees and adding to the width of the buffer?
No, we moved the fence in, so all the landscaping is on the neighborhood side of the fence.
So you didn't actually increase the width of the buffer?
The buffer has been 20 feet.
And so that hasn't been changed?
Correct.
Did you increase the number of trees?
No, that's pretty much the same that's been on the plan.
Because you didn't increase the number of trees there?
No.
So is that the only change? You just changed where the fence is?
We pulled the fence in, yes, 16 feet off their property line.
Is there any reason that you cannot add additional deciduous or non-deciduous trees along that buffer line?
No, we thought we'd put in a pretty significant amount, but more could always be added. But
Okay.
once you put in more, it could kill off.
All right, and you now say that the total area that is impervious, including the area that's somewhat porous, is 68.7% of the property?
68.7,
And what does the ordinance allow? What is the maximum the ordinance allows?
40%.
40%.
Correct.
And in order to get it closer to 40% or to get it to 40%, you would have to basically shrink the parking area. Is that correct?
Correct.
Are you familiar with lots used for storage of vehicles for dealerships where there is what they call dense packed parking, where you put parking, the cars together, since no one's going to access them except employees? Have you seen that in other dealerships?
No.
Okay, so you're not familiar with the dealerships along Route 22, Crystal City, and others where they have dense packed parking?
No.
Could that be done in order to achieve the same number of cars, but to increase the green area by moving the cars together and just simply have the employees move the cars when they need to get to one?
Well, the direction of our client was to make this, because they're higher end cars, be in a standard space,
But is there any reason that could not be done?
other than to keep the cars separated.
Right, to keep the cars separated like as if it's a parking lot.
Correct.
Correct. But otherwise, they could be parked more closely together, and you'd increase the amount of pervious area on a property. Is that correct?
If you wanted to stack cars, correct.
Now, let's talk about that entrance and exit on Old Post Road. You said that the gate is 18 feet wide. Is that correct? It's going to be?
Yes.
But the actual paved area is still going to be 24 feet wide?
Yes.
Well, if the gate's going to be 18 feet wide, why can't you reduce the width of the driveway area to 18 feet as well?
It could be.
I mean, wouldn't that reduce the concern about converting that entrance into a regular entrance and exit for either customers or to use for entrance and exit on a regular basis? Wouldn't that have that effect of reducing that likelihood?
No, because they're going to go through the PSE&G as long as that's still open.
Oh, well, let's talk about the PSE&G. You called it an easement. Is there an easement?
They have an agreement in place, from what I understand.
It's not an easement.
It's an agreement.
You didn't show recorded easement on your plans, did you?
No.
In fact, you called it on your plans a right-of-way. But it actually is owned by PSC&G, right? It's not just a PSC&G right-of-way. Is that correct?
Correct.
I mean, it's a difference between a right-of-way and actually owning a property. Is that correct?
No.
Oh, there's no difference?
No, for PSE&G's purposes. It's their right-of-way where they have their services in.
But does right-of-way speak to a right to go over someone else's property to use it for a specific purpose, whether it be access or otherwise?
Well, PSE&G owns it, whether it's a right-of-way or it's a property.
They don't need a right-of-way because they own it, correct?
Correct.
Right. So have you seen this agreement?
I've seen it, yes, but I haven't gone into detail.
Then has the township seen the agreement with PSC&G?
That I'm not sure.
Okay, so we don't know if it's been shared with the board or the board attorney to verify the terms and the length of it?
Not from me, no.
What's your understanding of what the right of the dealerships is to go through the PSC&G property?
They have the right to store cars there and go through that easement, through that right-of-way.
And how long is that right?
I believe they've had that in place for probably 30 years now, from my understanding.
Well, for the future, is it in perpetuity or is there a specific length of time?
It just renews every year, from what I understand.
Your understanding could be renewed every year. Can it be canceled at any year? You're not sure of that.
Again, I didn't write the agreement. I don't know the language of it, so I just know from what I've seen or heard.
All right, well, perhaps another witness can give us a little bit more information about that. Okay, the other thing is you testified about the existing use. The language I had down from your testimony in January was to access the existing parking area. And you then said to expand the parking area. Do you have an understanding as to whether the existing use of storing cars on this property is legal?
I'm not aware.
Have you gone under the understanding and testifying that it was legal or illegal, or weren't you given any information one way or another?
No, from what I understand, there was a survey done, I think, when Katina bought it back in the late 80s, that then they started using it for the storage of cars.
They started using it after the late 80s?
Around the late 80s when they bought the property.
If you had information indicating that it was an illegal use, would you still be saying it was an expanding of an existing parking area?
I don't know of it.
Would you still use that language?
I don't know what you're asking on that. It's what they've been used for. If it's been approved, I'm not sure.
I believe Mr. Schwartz is asking a legal question of an engineering witness.
I just simply asked him for his testimony. Would his testimony be different if he knew that the use was illegal?
You're asking him an
Can
assumption.
you answer that question?
If he can answer.
If you can answer it. Would it change how you describe what's being proposed?
Why don't you answer my question?
Hold on. Both of you can't ask the same a different question and go piggyback off of each other.
No, you're right.
No. If he can answer your first question, you can answer. If you can answer.
Let me say my question again so you understand it. Your testimony originally in January was that about the existing parking area. You said it was an expansion of the parking area. And my question to you was, if you knew that that existing use was illegal, would it change your testimony as to characterizing it as an expansion of the parking area?
I have to say no.
All right. Why is it necessary to have two openings onto Old Post Road?
Well, one is for the existing driveway for the existing home that's going to remain, and then the other driveway is for the inventory lot.
Is it possible to access the commercial portion of the use, the parking area, through that other driveway?
Yes, if we were to open up the driveway through there, yes.
Well, what is the purpose of that? If you're only going to use Old Post Road in an emergency through that other area that's either 24 feet or 18 feet wide, why do you need another driveway to get to the commercial area?
Because we're just leaving the existing house and it's set up just as it is and keeping the inventory lot separate from where it is.
Well, then, would you have any objection to closing it off so it couldn't get to the commercial area?
This is our proposal. We're proposing a driveway to the inventory lot and a driveway to an existing driveway to the single-family house.
So could that driveway be closed off so it would only be used for the residential portion of the property?
We have an existing driveway for the residential property.
That's what I'm talking about. Could that driveway be closed off so it couldn't access the commercial property?
Well, that is cut off other than an emergency gate.
Why do you need an emergency gate down there if you're going to have an emergency gate on the other entrance from Old Post Road?
Better to have two in case there's an issue where you can't get through that gate. You can go through the southern gate.
Is that typical on uses such as this? Do you need two different emergency accesses to the property?
I've seen two. I've seen one. It's kind of either one's typical.
All right, thank you. How many trees in total are you cutting down?
I'd have to go back and look at the plan. I'm not sure.
Well, you're not planting as many trees as you're cutting down, is that correct?
Correct.
And that's not in compliance with the ordinance, correct?
Correct.
Can you bring it into compliance by increasing the number of trees?
There's not enough space probably to put that many, so we're making a contribution to the township.
Okay, well, a good place to start would be along the property line with Ms. Bruguera's property, correct?
Sorry, is that a question?
Oh, I'm sorry. If I could finish my question, then it would be a question. A good place to start would be to increase the number of trees along Ms. Bruguera's property line. Is that correct?
Sure, yes.
All right. Could you also add, you have no buffer whatsoever on Mr. Szilagyi's side, do you?
No.
And I assume that's because that's a commercial use, correct?
Well, that's where the existing pavement is.
All right. But that's still a residential zone, right?
I believe all this is in the residential
All
zone,
right.
yes.
So you could still create a border along there, even if it's only 5 feet, of something with some sort of growth, could you not?
Could always add that in, yes.
And that would increase the amount of pervious area on the property, correct?
Correct.
All it would do would be it would reduce that the width of the driveway or aisle next to those parking spaces, correct?
We'd have to look at how we configure it then if we had it.
Yeah, and again, my suggestion, only because I've seen it at other dealerships, was a dense packed parking as opposed to making it set up as a parking lot. Is your drainage system entirely on your property?
Except for the outfall, yes.
Yeah, I was a little bit confused about, are you relying on another property for your drainage system?
Yeah, the outlet is on, I believe it's lot 480.01. It's the apartment complex.
Is there some sort of agreement with the apartment complex to maintain that part of the system?
Yes, they just recently signed off on that.
Is that going to be a recorded easement?
Yes, it is.
And is there going to be an agreement on the applicant's side to maintain that?
No, we don't. We're not on the applicant's property. I mean, the neighbor's property.
So who's going to maintain that?
Well, Katina will maintain their system that ties out to the stream.
Well, how about on the part that's not on the applicant's property?
Yes, that'll be still fall under the applicant's responsibility.
Okay, and that'll be part of the agreement?
Yes.
And you talked about there being security lighting on the property. Was that your testimony? I'm sorry.
Yeah, we're proposing lighting on the site, which will be motion censored, and then at night it'll click over to security.
And the security lighting, that's what you were talking about. You put hats on it, you put some sort of shields on it. That's part of the changes to your plan?
Yeah, so it doesn't bleed off the property. It's contained where the light source is.
Have you submitted to the township the foot candle measurements?
Yes.
And it's not going to be shining on other people's property?
No.
How high will those light stanchions be? How high will the actual light portion be?
12 and a half feet.
Can they be lowered at all?
We've lowered them down to 12 and a half feet.
Right. You're aware that Ms. Bruguera's property is at a higher elevation than the applicant's property?
Yeah, probably a couple feet. It keeps going uphill from there, yes.
Right, well, the rear part of their property where her house is more than a couple feet, is it not?
Yeah, 4 or 5 feet maybe.
So if she's higher, she's actually going to see a higher portion of the lights, and therefore, the more you reduced it, the less likelihood that she would actually see the lights, correct?
Correct.
Can you reduce it to less than 12?
Our proposal now is 12 and a half feet.
Can it go down to 10 feet?
They can, but our proposal is 12 and a half.
But it would still be efficient if we're at 10 feet?
We'd have to add more light poles.
All right. Is there a plan for where trucks will come in during construction? How it will access the property?
That hasn't been looked at yet.
would it be feasible to stipulate that the trucks are going to come in through the dealership side and not from Old Post Road?
I don't think that'd be possible.
So all the trucks are going to be going in and out of Old Post Road.
During construction, most likely, yes.
And trucks could be parked along Old Post Road?
I don't think they could park in the street. They'd have to be on site.
How long is construction going to take place?
That I'm not sure.
Will it take months?
I would assume so.
During that time, there'll be trucks coming in and out from Old Post Road?
Yes.
Are you aware that school buses go along Old Post Road?
School buses go up and down most roads, yes, okay.
Are you aware that traffic backs up to this property on Old Post Road?
No.
You're not aware of the traffic conditions at Old Post Road, is that accurate?
Yeah, I don't travel Old Post Road.
All right. That wasn't a consideration taken into account in construction of the, or in determining how construction was going to take place?
Yeah, again, no plans have been set for construction.
That's all the questions I have of this witness. I imagine that maybe other members of the public will want to question this witness.
You can continue with your case, and then the public will then have their opportunity individually.
All right, that's fine. All right, then next I'd like to question Mr. Gallagher.
Mr. Gallagher, raise your right hand. Do you solemnly swear or affirm to tell the whole truth, nothing but the truth, so help you God?
Yes, I do.
And just state your full name for the record and bring the microphone close.
Robert Gallagher.
All right, Mr. Gallagher, I'm going to ask you about some of the same fields as I asked the engineer. First of all, this agreement with public service, you testified about it last time, and tell us about, first of all, it is in writing?
Yes, it is.
It's not a recorded document.
No, it's not a recorded document.
Has a copy been given to the township to review?
I am not sure, but we have a copy. Peter has a copy here.
Would you have a problem giving it to the board's attorney to verify what's in it?
No, sir.
Right, now, exactly what rights does it, first of all, who is the agreement between public service and whom?
Public Service and Ray Catino Motor Car. And it's a use and occupancy agreement.
Okay, use and occupancy agreement. And what is the right of use and what's the right of occupancy?
We're allowed to use it for parking, storage of vehicles, and crossing over it. And it's been in effect since, I believe, it's at least 30 years now.
And you can actually store cars on the public service property?
Correct.
Is there any kind of map attached to it showing what area you can store cars on?
Yes, sir, there is.
That's part of the, you call it a use and occupancy agreement?
Yes.
As opposed to a lease?
Correct.
Right. And what's the duration of this agreement?
It's an open-ended. We renew it every year. And like I said, it's been in place for over 30 years.
Does Ray Catino, and I'm using Ray Catino not as the person, but rather the company, does Ray Catino have the right to renew every year? In other words, is it an option to renew every year?
It's been an automatic renewal. We contact PSE&G. We do our renewals. It's been in place for 30 years without question.
Yeah, but what I'm saying is that it give Ray Catino the right to renew every single year.
It is a long-term, I believe, Peter, you have to read the verbiage for me. I don't remember it off the top of my head, but it is an open agreement with no closing dates. And it is, in effect, can be canceled with 60 days notice, I believe, from either party.
All right, so if this proposal was built and then PSE&G cancels on 60 days notice, what's going to happen? What's going to happen with the access?
We would have to come back to the board and get access off of the old post road.
All right, so this is important. So your proposal is that access is going to be through public service except for the A, residential property, that second entrance, and B, for emergency use. And you have to come back to the board if that changes because of a change in the agreement with public service. Is that accurate?
No, it is not.
All right.
Our testimony before was the board requested that we close off the fenced access along the storage building in the lower left-hand corner, and we've agreed to that. All right. So that access is just a closed gate. It'll be chained off. We will access from the Route 1 site. across the PSE&G property onto this property.
All right, so PSNG cancels on 60 days' notice. What happens then?
We come back to the board.
All right, so this approval is not an approval to use, under any circumstance, to use Old Post Road other than emergencies.
No, we would have to be able to use that entrance or exit if we did lose temporary access to the PSE&G property also.
All right, and what do you characterize as temporary?
Well, we've lost it a couple of times over the years when they do tower replacement, cable replacements, pipelines went through and we replaced, and we were not allowed to use the access on that property at those points.
And for how long a period of time each time?
Oh, it could have been from a week to 3 to 5 months when they did the pipelines.
All right, so there could be extended periods, based on prior events, there could be extended periods of time where you're going to be using Old Post Road as your exclusive means of access.
If PSE&G restricts our access through that site, yes.
Well, based upon past practice, that, I don't want to say is likely to happen, but I will say it is likely to happen because it's happened in the past. It's happened more than once in the past.
Well, likely is an assumption. It has happened, and
How many times has it happened?
I would think 4 or 5 times in 30 years.
Okay, so that's 4 or 5 times. And how many times was it more than, let's say, 2 weeks?
Twice.
And those 2 times, how long was it each time?
When they dug the new pipeline, I believe it was a few months, and when they did the new towers, it was probably a month.
All right. And over what period of time is this?
Well, the pipeline may have been 10, 12 years ago, I believe, and the towers were fairly recent, within the last 2 years.
All right. So, and how long was it when the towers were installed?
I believe it was about a month that we lost access on this side.
All right. So within the last 2 years, there was a time where there was approximately a month when, if this were to happen in the future, then there would be a time when, during a month, you'd use Old Post Road exclusively. And if the other event happened regarding the pipes, then it would be 5 months that Old Post Road would be used exclusively.
I couldn't answer that. I'm not a construction engineer.
No,
I wouldn't
but
know.
based on past practice, that's what happened.
Based in the past, when they replaced the pipeline, yes. But that pipeline was 100+ years old when they replaced it.
I understand. And is that why you want to keep the driveway width 24 feet coming to Old Post Road? Because likely you're going to have to use that on a continuous basis at some point in time?
No, it's there for in case we have to use it. Not that it's
Will you
likely.
reduce it to 18 feet?
Like the engineer testified, he has spoken to the fire department. We have reduced it down to 18 feet. The one thing that I believe that was missed, that driveway was actually extended into the property too.
Can the driveway be made more narrow to 18 feet?
And not to give us a two-way in and out.
That's right. Well, you understand where I'm going, right? I mean, a very big issue is the concern about Old Post Road. I mean, that's obvious, right? And so on behalf of my clients, I'm asking you if you can reduce the width of that driveway to make it less likely that someone's going to want to use it for something other than an emergency.
My answer to that would be no, not at this point.
You're not willing to do that?
No.
Okay, because you want to keep your options open to use Old Post Road all the time someday.
Yes, I need to keep options
Right,
open.
because right now with public service, you've got a document that is 1 year renewable, and that's it.
Correct.
And allows public service at times to unilaterally tell you, you can't use it because I have to do something on public service that's going to stop your access. Is that correct?
That is correct. But
All
again,
right,
like I
thank you.
testified, I said, it's happened 4 or 5 times in 30 years. We also have a second piece that we lease, or not lease, I'm sorry, we have a use and occupancy agreement with PSE&G at one of our other properties. And that's been in place for another 20 years. And we've only had one issue on that when they did the towers, when they pulled the wires over. It was closed for 2 weeks.
But by the way, have you looked at other properties where you can store cars?
Constantly.
And this one, I assume, was chosen because of access, because it's right there.
Exactly. It's very efficient for our business on the Route 1 corridor and our campus.
Okay. So, but you're aware that it's in a residential zone as opposed to a commercial zone.
Yes, I'm aware.
Now, your use of it right now for storing some cars there, do you have any knowledge, does Ray Katina, and again, I'm not talking about the person, I'm talking about the company, have any basis for believing that's a legal use?
Did you say legal or illegal?
A legal use, L-E-A-G-L.
No. When we purchased the property, it was a commercial use in the rear. We started parking cars there from that date on, and that was it.
What do you mean by a commercial use in the rear?
In the rear garage, I don't remember exactly what the prior owner did. He did some cabinet work or a carpentry shop or something. He used that for his commercial vehicles and all.
Did you get a CO for it?
No, there's never been a CO issued for that.
Okay, did you ever make an application to a land use board to legalize it?
No, sir.
Are you going to have any security guards patrolling this property in the evening or on Sundays when it's not open?
No. We use that.
Typically on your lots at your dealerships, do you have security people who patrol it?
No, sir.
So the only security is going to be the lighting, essentially.
And camera systems, yes.
No alarms or anything like that?
No, sir.
No alarms on the gates?
Nope.
And you have an agreement, apparently, at Raritan Center to offload the new cars?
Well, we lease a 5-acre piece in Raritan Center for our prep center, and that's where all our tractor trailers go for offloads for all the dealerships on the campus.
Are you allowed to store vehicles there as well?
Yes.
So again, the only reason that you want this property is because of the ease of access to your Katina properties.
Efficient operation for our business, yes.
Now, if you lose the public service access, this just becomes like Raritan Center or anything else if you have to go through Old Post Road, right? That ease of access is lost.
No, Raritan Center has a building on it, has an actual service, not a service center, but a prep center in it. This would only be for storage of cars that were prepped, ready for delivery, and those type of vehicles.
That's not my question. If you were to lose the public service access so that now everything had to go through Old Post Road, this would be just like any other remote car storage location, correct? You would lose that access, that ease of access.
If we lost the
public
PSE
service.
If we lost the PSE and G access, yes, we would have to use this for the use we intended it for, car storage.
I had asked Mr. Lane whether he's familiar with the concept of dense parking for car storage. Are you familiar with it?
Yes, sir.
You know that like Crystal Auto does it on Route 22?
Not particularly that dealership, but I have seen dense storage, and it's not applicable in our type of environment.
Why is that?
Because of the vehicles we sell, the Highline vehicles, expensive vehicles, and it's not an efficient way to store cars where you're moving 2 or 3 cars to get one.
Well, when you say it's not efficient, it's not as easy.
No, it's not efficient.
Well, you'd need 2 employees who would come. One would back one car out. Another one would back the car out that you want to show to somebody. Then they'd back the first car in again, and that would be it, right?
Okay, you just supported my efficiency.
Because you have to use 2 people.
Can I finish?
Gentlemen, if we could speak.
My fault.
I'm sorry.
My fault.
Let me finish. You speak, then the witness speaks, okay? Just this way the court reporter can take an accurate record. You may proceed.
Sorry, Chairman.
Go ahead.
Me or?
No, answer, you can go ahead. I'm sorry.
Efficiencies. You said 2 people go and move cars and bring one out. In this type of environment, the way we have it set up, one person goes to the site, he has a set of keys, he brings the car out of the parking spot and brings it up to our dealerships.
So the reason I suggested dense parking is because it allows you to shrink the parking area, allows you to shrink the paved area, allows you to get closer to the ordinance maximum for pervious area, green area. And your reason for not wanting to do that is because you have to occupy 2 employees to move cars as opposed to 1 employee?
It's efficiencies, it's damage to vehicles. There's a lot of reasons why we laid it out this way. All our parking lots are laid out with this size parking.
Okay, but please answer my question. The reason you don't want to do those things in terms of reducing the excess paved area, reducing the area that's impervious, is because you don't want to occupy 2 employees moving cars. Is that correct?
That's a statement, I think. I don't think it's a question.
I'm just asking you, do you agree with that or not?
I disagree.
And so what other reasons are there that you wouldn't want to do that other than occupying 2 employees?
Well, it's efficiencies to operate the business. It's damages. It's parking the cars. It's just more efficient for us to have a 9 by 18-foot parking spot than have cars triple stacked or double stacked and moving 3 to 4 cars to get 1 car out.
It's more efficient to Ray Catina's company, correct?
More efficient to our business, yes, sir.
Okay, thank you. That's all the questions I have of this witness.
Okay. Do you intend to call any other witnesses?
I'd like to inquire of the planner.
Okay. Proceed.
Can I ask a point
Can
of
you bring the
order
microphone
question?
closer to you?
A point of order question. For follow-up questions, I would ask Bob, wait until he's finished, or do that now?
If you want, Ms. Schwartz, are you okay if he asks, since he's here?
Oh, sure.
Okay, go ahead. Thank you.
Can I ask you?
So, Bob, I'd like to show you a document
My glasses.
and ask you if you recognize it.
Yes, I do. I'm sorry. Yes, I do. This is the PSE&G agreement dated in 2003 that I signed.
Okay. And if you flip over that first page, what page is that?
That's the first page of the agreement.
And does it discuss the nature of your rights to that area, and does it speak as to a term?
It does speak 2 places. It says, this calls it a lease, and it says that it's for an indefinite term beginning in 1981. Oh, sorry, 1991.
Thank you. That's all I have, Mr. Chairman.
Okay, thank you, Mr. Licata.
I have not seen the agreement, but I'm interested in the provision that allows either side to terminate on 60 days' notice.
If you want to peruse the document, feel free, Bob. You've testified that it is terminable upon notice.
The Main Street.
Can
one
I,
is on the first
yeah, can I direct your attention to section 1, about 2/3 of the way down the page? Does it speak to a right of termination?
page. 10 days termination on this one,
No.
right?
Are you looking at the page?
Oh, I'm sorry. I went right over it. I'm sorry.
I know you can be nervous testifying in front of a group. What does it say?
No, it's reading legal documents.
Okay.
It does say 60 days written notice from either party.
Either party?
Yes.
Right.
And
What
that
is the 10 days?
I'm sorry, what was the
What is
question?
the 10 days?
It refers to 10 days during the termination period, right, Peter?
It speaks, well, at the risk of testifying, it's in the event of a default, there's a 10-day termination notice that we would stipulate is contained in this document.
All right.
We haven't defaulted in 30 years. We're not going to default.
Thank you, Bob.
Okay, Mr. Schwartz, you're going to call the planner next?
Yes.
Okay, all right.
Thanks, Bob.
Sir, raise your right hand. Not tonight. You weren't sworn tonight. We're going to swear you in again. Raise your right hand. Do you solemnly swear or affirm to tell the whole truth, nothing but the truth, so help you God?
I do.
And please state your full name for the record.
John Taikina, Taikina.
And Mr. Taikina, you were previously accepted. Are your licenses in good standing in the state?
Yes.
Okay, great. You may proceed, counsel.
All right, sir. In your testimony, you start off by testifying that the property was being presently used for storage of vehicles. Do you recall that?
Yes.
Did you make a determination as to whether the use was legal when you made that statement?
No.
All right, so if you knew that the use was illegal, would you have testified that the present use was a justification for expanding the use if you knew it was illegal?
I never testified that it was an expansion of a non-conforming use. I testified for a D1 use variance for a use not permitted in the zone.
Well, let's talk about that. Did you consider the master plan in determining whether the use was, the property was particularly suitable?
I consider the master plan in terms of the negative criteria consistent with the statute. I considered the particular suitability separately.
Well, the master plan is the document where the planning board says what it considers to be appropriate uses of land in the township. Is that correct?
That's your opinion.
Well, what do you think?
I think the master plan sets forth the land use plan for the community.
And what's the land use plan for this property?
RB.
Which is residential, correct?
Yes.
And in fact, the master plan was re-examined within the last 10 years, correct?
Yes.
Did you read the re-examination plan report?
Yes.
And the re-examination report actually talked about the RB zone, did it not?
Yes, it did.
Do you remember the context in which it discussed the RB zone?
Yes.
What was that context?
It talked about the large number of variances that needed to be granted within the RB zone.
What kind of variances?
The variances in that context were for structures on undersized lots and how they could be accommodated with deficient setbacks, et cetera.
Well, actually, it talked about bulk variances, didn't it?
I believe I just described bulk variances, sir.
And it didn't say anything about use variances, did it?
No, it did not.
And you can read that re-examination report and you will not find anything in it that recommends a change in the RB zone to commercial uses. Is that correct?
Yes, there are no references to changes in the RB zone.
So we have two master plan documents, the master plan and the re-examination report, and in neither of them is there any statement about changing the permitted uses in the RB zone to commercial use. Is that correct?
It is correct. The standard, as this board knows, is would there be a substantial impairment to the master plan?
Okay.
Excuse me, I'm not finished.
Well, I asked you a question, you answered the
All
question.
right, gentlemen, we're not taking a step further.
But if I ask a yes or no question and he answers
You're not going to
it,
overspeak me, though.
that's the end of the question.
You're not going to overspeak me, though. You understand that?
Yeah, sure.
Thank you. Yeah, you're sure. So we will allow, sir, you're out of order. Sir, no, you're out of order. Sir, officer, sir, if you continue, you will be removed from the chamber.
Please don't touch his right shoulder. Don't touch the right shoulder. Let go.
Let go. Barry. Let go. He's asking you to sit down, okay?
Yeah.
Please sit down.
How many times has he overspoken an attorney in a proceeding? Yes or no?
Sit down if you
Oh,
want
you've
to
been in
stay.
court too, right?
Sit down if you
You've
want to
seen
stay.
it.
Want to stay or?
Sir, if you could please, no more outbursts. Sir,
If you would please.
I'm going to do my job. Thank you. Sir, I'm going to ask both the planner, the attorney, the professionals. The court reporter is taking a record of the proceedings. Please do not make her job harder than it already is. You may proceed.
But hold on 1 second. Mr. Schwartz, we are not in a court of law. So when somebody is speaking and they wish to elaborate, they are permitted to clarify their testimony. You can't cut them off. I don't rule on objections of that nature. Again, I'm not a judge. This is not a court of law. Just as everyone is going to accord you the professional courtesy of completing your question entirely, you're going to accord, because this has happened a few times tonight, you're going to accord each and every witness that is questioned the professional courtesy of responding fully as they wish to elaborate. They're allowed to do so.
Thank you. And I just asked that the witnesses answer the question as well.
That's nice, but he wasn't done.
Sir, you testified that...
Sir, he was not done. I need to finish hearing it for the record, as a court reporter needs to finish taking down his entire statement.
I frankly don't remember the question, so.
Sir, you testified that originally that the lots could be developed into single-family dwellings. Is that correct?
Yes.
So it is not the case that this property cannot be used for its own purpose. Is that correct?
Yes.
And if you did develop it into single-family dwellings, that would be more consistent with the residential uses in the zone, correct?
Yes, and in our opinion, that would have a greater impact on Old Post Road and its traffic than the proposed use.
I think you testified that you could fit 8 houses on this property. Was that your testimony?
Yes.
Did you look at a plan that laid out 8 houses?
Yes.
Did you show a road for these 8 houses?
Yes.
Did you look at the bulk requirements in the RB zone for those 8 properties?
Yes.
Do you have that plan with you?
No.
Did you have the plan in your office?
Yes.
Who prepared that plan?
I did.
Are you an engineer?
No.
Are you an architect?
No.
So this was a planner sketching out an 8-lot subdivision?
As provided for in the planner statute, yes.
All right, so you're not claiming the property cannot be developed for a conforming use, is that correct?
We never have.
Now, you also did a tax benefit analysis?
Yes, I prepared a fiscal impact analysis as required by the ordinance.
Okay, is there somewhere in the municipal land use law that talks about a tax benefit being a basis for a use variance?
No, there is a requirement in the Edison Township Municipal Ordinance that a fiscal impact statement be submitted with an application.
Would you agree that that's not a planning basis for granting use variance?
We have never testified that it would be a basis for it. We testified that it was a requirement to submit one, and we submitted one.
I got it. Thank you. Did you do an analysis of the uses in the area in the RB zone, the existing uses?
Yes.
Now, there's a commercial use to one side of the property. That's correct, Mr. Szilagyi's property?
Yes.
What's on the other side?
A single-family home.
And what's across the street on Old Post Road?
A series of single-family homes.
So the area, and then on the other side of Ms. Bruguera's property, there's a church?
Yes.
And on the other side of the church, what's on that side?
Additional single-family homes.
All right, so would you say that the characterization of the neighborhood is that it's single-family homes except for Mr. Szilagyi's and the church?
I testified that it was a mixed neighborhood, and as evidenced by the exhibit on the board.
Well, you say it's a mixed neighborhood, but you just testified that at least 5 or 6 of the uses are residential, and then we have a church, and then we have Mr. Szilagyi's property. So wouldn't you say that the character of the neighborhood is residential?
I testified that it was a mixed neighborhood.
All right, so you're not going to agree with me that the character of the neighborhood is residential?
No.
Your reason for saying the property was particularly suited for the use was because it was of its proximity to the Katina property?
Yes, that was one of the reasons.
If that PSC&G access was no longer available, if there was a wall put up there, so the only way in and out would be Old Post Road, would your testimony change?
Not significantly.
When you say not significantly, would change somewhat?
Somewhat. There is not a direct connection. It would only be a proximate property then.
Okay, then it would have physical proximity, but it wouldn't have the access that makes it hand in glove with the Katina property, correct?
It would be different.
All right. So you're putting, if you put all the traffic, bringing in the cars from the offload site, bringing in the employees in and out from Old Post Road, would that change the character of this application because it's no longer connected to the Katina property?
That is not the proposal before the board.
But if that, well, that is a part of the proposal because the applicant just said that it's probable that sometime in the future there's going to be at least a temporary cessation of use of the public service property, if not a permanent one. So let's address that. What would happen if there was a wall put up, you can no longer use the public service property? Would your testimony change?
It would be a different proposal than the proposal that is before the board now.
Would your testimony change?
It would be a different proposal than the proposal that is before the board now, if you would allow me to complete my next sentence. The applicant has testified that we will access the property via PSE&G. The applicant further testified that over the last 30 years that PSE&G has been in availability less than a cumulative approximately 6 months of time was that not available. I would submit to the board that having the property not available for 1 or 2% of the time is not a significant amount of time for the access to be changed.
All right, so that's your testimony, that it's not that much time that they wouldn't be able to use the public service property. Is that your testimony?
That was the testimony of Mr. Gallagher based on his 30 years experience.
So do you consider 5 months to be a long time of not being able to use that connection?
I don't recall 5 months as being the testimony. I think it was 5 months cumulatively over the 30 years.
Well, I guess we'll just have to let the record speak for itself on that. Would you consider 30 days blockage and having to use Old Post Road constantly on a daily basis? Would that change your testimony?
In the context of 30 years, no.
Now, you read the Bignell report dated July 5th, 2022, correct?
Yes.
And the township planner said that the proposed use is not consistent with the land use recommendation of the master plan for single-family and vacant land use. Do you disagree with that?
No, I agree with Mr. Bignell that the RB zone is a single-family zone. We acknowledge we are not a single-family use. That is why we are seeking a D1 use variance from the zoning board.
You're also familiar with the Medici case, obviously, correct?
Yes.
I mean, the Medici case is one of the bellwether cases that we use for standards of granting use variances.
Yes.
And you're aware that the Medici decision requires an enhanced burden of proof on the negative criteria for use variance?
It requires an enhanced burden of proof, yes.
And one of the things that Medici says is that municipalities should make zoning decisions by ordinance instead of variance. You're aware of that language in the Medici case?
I am.
Now here, where you're putting a purely commercial property with 68% impervious area in a residential zone, which could very well require access, ingress and egress into the residential zone if the access to the commercial area is blocked off either temporarily or permanently. Is that not rezoning this property?
No.
This use has no characteristics of a residential use, does it?
It has a residential home on Old Post Road.
Okay, it's got a home on Old Post Road. Now let's talk about the car storage area. That's a parking lot, correct?
Yes.
And that has no characteristics of a residence. This is not a transitional use, is it?
I actually testified that it was a transitional use between the intense commercial use that is located to our east along Old Post Road. I believe that's your client's property, and the balance of the single-family neighborhood. We provide a single-family home along Old Post Road. We provide a substantial buffer along Old Post Road and a substantial buffer to our residential neighbor to the west.
So someone driving towards Route 1 on Old Post Road, they will see Mr. Szilagyi's property. They will see a house. Then they will see a parking lot. On the other side, they're going to see all houses. Then they'll go to another residence. So that parking lot is a transitionary use?
They will see a house and they will see a driveway.
Driveway.
The parking lot is substantially back from the
Mr.
street.
Schwartz, would you please let him finish? I need the court reporter to be able to take down both of you, and he was not complete. This has happened more than once. Let him finish. We're not in a court of law.
The property provides for a single-family home and then for a driveway along Old Post Road. We provided substantial buffering to our property to the west. And as Mr. Lane testified, if additional trees need to be added, they can be added. If additional buffering need to be added along Old Post Road, that could be added. The applicant has already made substantial improvements to the plan to accommodate the comments of the board and the comments of the professionals. And I think the applicant has shown a willingness to do the appropriate thing in terms of the property and the use.
But in the end, are you done? Are you done?
Yes.
But in the end of the day, we're talking about putting a parking lot in a residential zone. Is that correct?
We are talking about putting a new car storage lot in a residential zone. A lot that is for the storage of cars that are then accessed and taken to a new car dealership. It is not a regular parking lot with regular access onto and off of the street. It is a very unique situation.
Thank you. That's all the questions I have.
Okay, thank you. Counsel?
I have one question for the traffic engineer, if he's still here.
Sir, raise your right hand. Do you solemnly swear or affirm to tell the whole truth, nothing but the truth, so help you God?
I do.
And please state your full name for the record.
John Ray, REA.
And Mr. Ray, you were previously accepted as a professional in your field. Are your licenses current and good standing?
Yes, sir.
Okay, then you may proceed. Counsel, you may proceed. Thank you.
You know, I think I lied. I think I have two questions for you. I apologize. My actual question was going to be if you're familiar with the ordinance that created an access easement from the Ulensis property through this property to Old Post Road?
No.
I didn't see it on the plans, and yet there was an ordinance that is on the books, and as far as I know, has never been overturned, of a easement agreement going from, involving people named Swales, that goes over the Ulensis, from Ulensis Court to Old Post Road. You're not aware of that at all?
No.
Is the applicant aware of it?
I wouldn't know. I'm not the applicant.
Well, I'm asking Mr. Licata, are you aware of that?
I'm not under oath to answer questions.
So he's really not going to answer that question. The attorney for the applicant is not going to answer that question if he's aware of the easement agreement. You refuse to answer that question?
Your question is fatally flawed in that there is no easement. There was an ordinance adopted by the town that stated it was interested and willing to enter into an easement, but no such easement has ever been created. And if I can so stipulate, when we were before this board in 2020, that issue was looked into as part of our subdivision and consolidation application. It was reviewed as a function of the approval of the Edison Glen development. There was no condition of that approval that such an easement be created to access the footbridge at the rear of the Edison Glen development. And we also submitted our client's title report for this property, and there is no easement in that chain of title. So when you state, sir, that there is an easement, there's a requirement for an easement, I submit to you that is simply incorrect.
Thank you. I'm glad that you answered that question. Ms. Shaw, maybe you can give me some insight into this, because I've raised this question before and I'm getting an answer for the first time tonight. Was that ordinance ever changed, or is it just simply never acted on?
Mr. Schwartz, everything that Mr. Licata just indicated is accurate, and there was a prior resolution, and it was looked into by this board. Now, those records are available. They're public records. So if you'd like, you can certainly look at those. But that's been the case. He's not inaccurate in how he indicated that.
All right, thank you. Thank you for giving that. We actually did 2 Oprah requests, and we got the ordinance, and we got nothing else that told us anything about that agreement. So we
It's
did everything we
impossible-
could.
Mr. Schwartz, it's impossible to prove a negative, isn't it?
All right, well, you didn't answer the Oprah request, so I can't blame you for that, but we did try to get the answer, and this is the first time I've gotten it. All right. To the traffic expert. Do emergency vehicles need a 24-foot wide access from Old Post Road, or would 18 feet suffice?
18 feet would suffice.
Did you do a study as to how vehicles back up, or to what extent they back up on Old Post Road during rush hours?
I've done traffic counts on Old Post Road. I've been to the site on several occasions to observe traffic flow, so I'll answer that. If you want to follow up with another question, I'll answer it.
Were you there during rush hour? Let's say.
Yes, I was there during rush hour this evening between 5 and 6 o'clock.
Mr. Ray, I'm going to say the same thing
I'm sorry.
that I said to Mr. Schwartz.
Thank you.
You have to let him finish the question for the court reporter to take it down accurately. Then you may answer.
Yes.
Do cars back up in front of where you would put that 24-foot wide access driveway on Old Post Road?
I haven't observed that during my visits to the site, including today between 5 and 6.
Is this the only time that you were at the property between, let's say, 5 and 6?
No, I've been out to the site on several occasions during the morning and afternoon peak hours.
Do you know where school buses stop on Old Post Road in
I
this
do
area?
not. No.
You don't know that? Do you know how often school buses go by on Old Post Road, go by this property?
I do not, but there are residences on Old Post Road, so I assume there is school bus traffic on Old Post Road.
Do you know how wide Old Post Road is there?
It's 1 lane in each direction. I didn't physically get out and measure the width. It's a 2-lane road, 1 in each direction.
Is there a shoulder?
If there is, it's marginal. It's not a full width shoulder.
Is there a sidewalk on that side, on this side of Old Post Road?
I don't recall.
That's all the questions I have of this witness.
Okay.
And again, I assume that other members of the public would like to question these witnesses.
Well, if they do, they'll have that opportunity. As I stated earlier, they're going to have that opportunity during their own appearance.
Well, Mr. Chairman, I appreciate that, except that I would like my witnesses, especially our planner, to have the benefit of all the testimony before he testifies. We have a planner here, and the questions could elicit more testimony from the applicant's witnesses. I'd like to have the benefit of that before we put on our witnesses.
I appreciate that. However, that's not the procedure of this board.
I see. Well, then I'll have to reserve the right to bring my witnesses back after more questions are asked of those witnesses. So would you like me to?
Mr. Schwartz, that's not how this board operates. If you want to present, you as an objector attorney get to present your information and your testimonies and witnesses first. Once you have presented them, they get to do any redirect and provide any additional information. You get an opportunity at that time. And then after you are done, then the public will get to weigh in, simply because then they'll have the benefit of your planner, your representation of your objectors, and they will have heard responses there too. So that is the way this board operates and has for the longest time. So if you'd like to continue, you are welcome to continue. But there is no reserving further. You need to move forward if you're going to.
All right. Well, you've heard, my concern, but with that concern, I will present my witnesses.
You may proceed.
First, Mr. Szilagyi.
Mr. Schwartz, if you'd like to have that microphone and sit at that chair, Mr. Szilagyi can stand with that microphone because he is a witness and you're
Where would
in
you feel
your
more
counsel.
Okay, then I'll go over here.
Good evening, Board.
Mr. Szilagyi, would you raise your right hand? Do you solemnly swear or affirm to tell the whole truth, nothing but the truth to help you God?
I do.
And I know you stated your address for the record, but I understand now you will be questioned by your attorney. So if you could just state it again one more time.
614 Old Post Road.
Mr. Szilagyi, I know you have a statement you want to give to the board, and I don't want to take too much of your time. So you own the property that's next door to the subject property, the applicant's property, correct?
Correct, to the east side.
All right, and I know the question is going to come up that you have a commercial use there. Is that correct?
Correct.
Is it a legal commercial use?
It's legal.
On what basis?
We had a variance.
Well, you got a variance to use it for commercial use.
Yes.
Is there also residential use on the property?
Yes.
How many residential uses?
2.
And what percentage of the property is residential as opposed to commercial?
I would say probably 60% is residential, 60 to 70.
All right. So you have a statement you'd like to give to the board?
Yeah.
All right. Why don't you go ahead?
Yes.
Counsel, since you are speaking for Mr. Szilagyi,
No, I'm not speaking for Mr. Szilagyi.
no, you are, but since as his attorney, you're representing him. You can question him as a witness.
Well, I want to let him get to his statement.
But he's not allowed to give a statement because he's retained counsel.
What would you like to tell the board about this application?
I feel that it's a bad move. It's a huge development and a majority residential area, and the use that they have there now, they have not been the best of neighbors. There's cars speeding in and out from the dealership. The biggest, there's a lot of noise pollution when they come in for a car. They hit the buttons and on their keys, and the alarm goes off till they find the car. And that's a lot of noise pollution. The brook there, Millbrook, he could have all the engineers in the world. I've been in construction for 45 years. That brook overflows, not onto my property, thank God. It overflows to the east towards the turnpike. I've seen it go into the turnpike. Now you're going to add 2.5 more acres of parking, of stormwater going into this brook. The stormwater, some of his stormwater is going right into the storm sewer pipe out on Old Post Road. That's not even in a retention basin. The blueprint Katina has, and I'm not referring to Ray Katina personally, but the business, shows an easement through the back of my property, which there is none. There is none. I know they said they're not going to use it anymore. They're going to stay off my property. I have nothing in writing, and I have nothing in writing about an easement in the back of my property. Our family's been there almost 90 years. When we started, it was Raritan Township. We had farm animals. There was no zoning. So I just, like I say, and it's a residential area. The lights that they have come through to everybody's house from Old Post Road. I mean, from Route 1, the dealerships, because they took down all buffer. So I think it's very unfitting.
Are you done? I have one question for you. If this were approved, and I know you don't want it approved, but if this were approved, would it benefit the residential portion of your property if there were a green buffering along the lot line between their property and your property?
Well, that's the first thing we looked at. I mean, he paved that lot of this use now, and I haven't said anything, but all that water just runs off into our property. I've never said anything in all these years that they've been there. They paved it. It wasn't paved before. My father built the house that was there next door, so We just live with it, but it's getting too much. It's just out of control. And all the traffic on Old Post Road is crazy. Come out, see it. Come out. Come to the brook in a storm. I'll show you. It overflows the bank on the other side into the Colonial Pipeline.
Okay, that's it?
I think so. Like I say, and then the board needs to look at that bridge, pedestrian bridge that was put in for Elenchik Senior Center, because I was going to bid that job as a contractor. The town put it out for bid. I'm going to say in the early 2000s, I didn't bid it, and it was for emergency access from Elenchik's out the back door, across the pedestrian bridge, to a path that headed toward Mary Brigier's house, and then it veered along, it was the 610 property down to Old Post Road, but with a mulch path. So, and there is an ordinance that was granted by the Swales family, he has it right there, that permitted that use. So if the Elenchik Senior Center, God forbid, something happened, a fire, hostage situation, the town required that back then. They don't need it now. I don't understand that. I don't understand. There's going to be a problem. There's a potential major problem there, and nobody knows anything about it. The fact that that bridge doesn't get maintained, or the emergency, whose fault is that? Is that the fire marshal? I volunteered on Edison Fire for 16 years. Whose fault is that? Somebody needs to check into that, because there could be an emergency tomorrow, and then there's going to be a big lawsuit for you guys, everybody. That concerns me. I've been there too long. That's all I have to say.
Thank you.
Wait, Mr. Schwartz, I'm sorry, Mr. Salaji? Just so you know, if you can just reapproach, so Mr. Licata is allowed to cross-examine.
Oh, I'm sorry.
No problem.
I'm
Mr.
sorry.
Schwartz, have you concluded your
done,
question?
thank you.
Okay, all right. Mr. Licata, do you have any questions?
Thank you, Mr. Chairman, but I have no questions for Mr.
Okay, all right, thank you. Mr. Salaji, thank you so much.
Thank you.
Mary Brugier. Could I ask the applicant to remove that? And I'm going to do my very best to put pictures up there.
Certainly.
Ms. Brugier, would you raise your right hand? Do you solemnly swear or affirm to tell the whole truth, nothing but the truth, so help you God?
I do.
And just, again, please state your address and name for the record.
Mary Brugier, 600 Old Post Road.
Ms. Brugier, where do you live in relation to the applicant's property?
I live adjacent to the pending proposed parking lot.
If you were standing on Old Post Road facing the subject property, you'd be to the left?
Correct.
And can you characterize, I don't know how to get back into the screen. I'm showing on the, I've got the picture on the,
Mr. Chair, if Mr. Schwartz needs a 5-minute recess to reconnect, I have no objection.
well,
Mr. Schwartz, are you?
I'm gonna need somebody to help me to reconnect.
Okay, well, we can do that, and we'll give the court reporter a chance to rest her hands, okay?
Absolutely.
All right, so it's 9:21, return 9:26. Thank you.
Okay, you ready to go?
Go ahead. Hit it again.
Just give me 1 second, Mr. Schwartz. I just want my vice chairman to come back. All right. Mr. Schwartz, you may proceed.
All right, thank you. Mary Brugier has been sworn, I believe?
She has been sworn, yes.
Okay. And Ms. Brugier, we just identified that you live on Old Post Road. You're to the left of the property. That's yours?
Correct.
Okay.
Correct.
And you want to tell the board something, don't you? But keep in mind that I'm trying to handle these pictures. And so, give me a break on how I maneuver. Now, all these pictures and videos we're going to show, these were all taken by you?
Correct.
And they all accurately show what you saw out in the field when you took the pictures?
Absolutely.
And when were the pictures taken?
Over the course of the last 9 months.
Okay, thank you. All right, so what would you like to tell the board?
First of all, thank you very much for this opportunity, and thank you for the time that you donate to Edison Township. My parents...
Microphone, Mike.
Could you just bring the microphone closer, ma'am?
My
Thank you so
parents
much.
bought 600 Old Post Road about 70 years ago. Upon my mom's passing about 25 years ago, I did purchase the home. It's the home I've lived in for most of my life. The property line is just inches away from the proposed parking lot. My lot runs 1.25 acres deep, which is unlike any other piece of property in the area. This proposed lot will run the entire length of my property as well as it will traverse the back of my lot. I am a psychiatric nurse. I use my home and my yard. It is my haven. I use it in all seasons. I hang my clothes on the line. I play with my dog in the yard. I plant flowers. I'm fortunate enough to have a plethora of nature around me, which I enjoy totally due to my stressful work life. I have deer and foxes and rabbits and a plethora of wildlife, which includes blackberries that I've picked since I was knee-high. The property houses 2 car garages and an outbuilding, which was my dad's workshop. Physically, as discussed, the home sits at a higher elevation, which unfortunately yields a lot of noise from Route 1 as well as the turnpike. Unfortunately, since there have been a lot of trees removed due to the expansion of the Ray Katina Corporation on Route 1, it's much noisier now. I look out my second floor window and I see just the very narrow strip of trees that's there that eventually, if this goes through, will be eliminated. And this, of course, now allows me to see through to the turnpike. As discussed, the building next to this narrow group of trees, which is the proposed parking lot, there is a brick ranch, which is owned by Mr. Katina. I'm sure most of us feel that it's only a matter of time before this small buffer of trees is enhanced and this lot becomes, again, something that is added on to an existing dwelling. As Mr. Szilagyi indicated, there are frequently horns sounding repeatedly because the workers cannot find the vehicles that are parked, and so we constantly hear beep, 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 beep until they find the vehicle. I actually, yesterday afternoon when I walked out of my home, and there is a shot of that. And
Okay, before we get to the pictures, Mr. Schwartz, do you have a set of the pictures for this board printed out?
No.
Okay, then how are we marking them? Because the record has to be clear. I have no method to mark a video screen.
I will identify them as I go through, and I will provide you with a copy within the next week. That's when we were doing remote hearings by Zoom. That's exactly how I did it.
Okay, so I'm going to ask that today is Tuesday, that by the end of the week, if the board secretary can please have a set And as you mark them, we're going to have to identify them more clearly than that because I have no method of marking them right now.
Well, what we're going to do is we'll identify what each one shows. And because they're in sequence, I'll be able to identify them in sequence.
Okay, but I'm going to still want to stop you to make sure we identify them. You're also going to have to provide a copy to Mr. Licata. Okay?
Sure.
Okay.
The proposed plan allows the Cantina dealership to have 3 driveways on Old Post Road in less than 900 feet. This section of Old Post Road has no curbs. One side has no sidewalks. There are parts of it which have blind curves, and there are divots in the road for the sewage drains, often not negotiated properly due to speed, which is another issue that's not patrolled. There is also a significant drainage problem coming from the Harts Mountain property, whereby the right-hand lane as you're going up Old Post Road toward Route 1 completely floods over and becomes a solid sheet of ice. The lights that we speak of from the proposed lot that were such a big topic in January and actually we're still not really clear on, will run the entire length of my property. Who is really going to enforce or check whether the height of the light is 17 feet or 12? Once this is done, who checks and verifies this? Surely my privacy will be invaded. I also want to share 2 unfortunate stories that happened to me personally due to the location of my home with the Ricatina dealership. I had brought my mother home from the hospital, put her up into bed, left my pocketbook and her pocketbook in my car. My car had been stolen, totaled, and became a rape crime scene. When they picked up the people that stole the vehicle, one of them was a minor and wasn't chastised or punished at all, but the other person said that they were passing through my property to get to the Ray Katina showroom to steal a Mercedes-Benz. Instead, they stole my mom's pocketbook, my pocketbook, and my car was totaled. About 4 years ago, I found 5 big wheel tires in plastic bags leaning against one of my outpost buildings. At that time, I called the showroom to tell them that I had some of their property. I called the police, they came. I asked them if they could please surveil Old Post Road and quite possibly my property because my driveway does run deep. I live alone and it's a dark piece of property. The officer told me I had to call the police headquarters. When I did, I was denied this. So you can understand, still as a single woman, the fact that there's going to be something even closer to my house is very unsettling. Since COVID has been lifted, traffic on Old Post Road is horrendous. It's sure to get worse once Hart Mountain is totally developed. On any given day, at any given time, the traffic backs up. We are unable to get out of our driveways or in them. This is not during rush hour. For many years, along the back of my property, Mr. Catina's corporation has been using PSE&G for employee parking and inventory. At times, there have been abandoned vehicles left there. Employees were eventually parking on Mill Road, which is a very busy intersection. It's the place where the new Ray Katina showroom is for the 3-story Porsche building, which is yet to be developed totally. There's 4 bus stops that are right at that intersection as well. And again, the traffic just backs right up. There is actually a slide showing 4 different buses caught in traffic.
Ma'am, I'm sorry to interrupt you, but if you could just identify it while you're going through, just so that we can just keep the presentation moving. I'd appreciate that.
Okay.
Mr. Schwartz.
Okay. I'm sorry, I missed my cue. I apologize.
You're on.
I'm going to go through these sequentially. So you need to tell me where you were standing and what this shows and at what time of day.
This is dusk in front of my house.
Okay, where are you standing?
I'm standing in front of my house.
Okay.
This is going to be 01, Mr. Schwartz, 01.
Sorry?
So we'll start with 01, and just for the record, it appears to show a a number of cars with taillights.
And in what direction are the
Mr. Schwartz, actually, she stepped away from the podium, but while we have a break, we'll let her get a drink of water. If you could just bring the microphone closer to you, please. Thank you so much.
In what direction are the cars traveling?
They're traveling up the road, up toward Boston Market, Route 1.
Is that in the northerly direction?
I guess. I don't know directions, sorry.
Okay, it's toward Route 1. And what time of day?
Dusk.
Dusk. And when was it taken?
I don't know. I have to pull it up. I don't know.
Approximately, was it before we went on daylight savings time?
Yes.
All right. Anything else you want to say about this picture?
This happens all the time.
When you say all the time, how many times a week?
Every day.
All right, I'm going to show you O2.
Same scenario, different direction.
Where are you standing now? Well, there's a sidewalk. Which side of the street is the sidewalk on? Your side or the other side?
Okay, that is the opposite side of the road, the opposite side where the parking lot is scheduled to go.
And it's showing, just for the record, it has a row of cars with headlights.
Are those cars going towards Route 1 or away from Route 1?
Folks, I'm sorry, if we could just allow the witness to answer the question.
Toward.
Same time of day?
Yes.
And you said that was dusk?
Yes.
All right, anything else you need to tell us about this picture?
Happens every day. This is my this is my beagle Seamus, but it is showing the property just behind him, which will be eliminated.
What portion of what you see is not on your property, but rather the at 604?
Immediately behind that log.
And this is O3 for the record.
This is 03, and it shows the beagle. And when was this taken?
Fall, late fall.
This is a video, and tell us where you were and what it shows. This is 04.
I am.
Okay, wait, hold on. Can you pause that video, please? So, Mr. Schwartz, this is now a video. Now we're going to have it provided in disc format to Mr. Licata, myself, and the board.
It'll probably be on a thumb drive. I think that's how we're doing it.
However it is, because depending on what the board decides and somebody decides to appeal, I need the record to be clear. So I'm going to call this video 04, but I will need it.
I understand. Okay, where were you standing? What time of day? And what does it show?
This is approximately 3:30 in the afternoon. There are 4 school buses that are going by. You can see actually in my rear view mirror, there's another one that is coming down from the opposite direction. They're in this big line of traffic. Like I said, nothing new. Right there is the new driveway for the Porsche building. There's, 4 different bus routes that stop there. That's the no through truck traffic, which.
Where's that sign located?
That's located down at the end of Old Post Road as it just comes off of Woodbridge Avenue.
This
Okay,
will be
going in
over-
which direction?
If you followed in that direction, it would lead you up to Route 1.
And this is 05. All right, so no through truck traffic. Do you know if there's a size or a weight limit? I mean,
And-
can an Amazon truck come through?
Yes. Previously, it's tractor trailers that were restricted.
Do you know if that's a 4-ton limit?
I do not. Yes, I'm told it is.
Okay, 06.
06 is more of the development of the Porsche building. The reason why I felt that this was critical is because from my home, you can hear a lot of the noise. Unfortunately, I was not able to capture that, but
And what time of
again,
day is this taken?
dusk.
Okay, that's 06, development of Porsche building. I don't know why some of these are coming up and some of them aren't. Okay, this is going to be 07.
That's at the end of my driveway.
And what does it show?
Traffic, both directions, going out over the turnpike overpass.
What time
Nothing-
of day did you take this?
Nothing new. I honestly don't remember what time of day I took that.
Well, I mean, it's obviously daytime.
Yeah, yeah,
Is it also, is it a weekday?
yes. I do have a video of traffic on the weekend as well, on a Sunday.
Okay, this is 08. Appears to show buses. Where were you standing and what does it show?
I was standing at, Brian, what's your house number? I was standing in front of 575 Old Post Road.
Where is that in relation to the applicant's property?
Where is it in relation to, Mark?
The applicant's property.
Up the road, I don't know, like 700, 500 feet up the road, closer to Route 1. You could see all the buses, how they have to wait in the traffic. And you can see, I just caught the bus in my rearview mirror as well. So there were 5 buses during that time. I had sat there for minutes, stuck in traffic. These are the deer that will be removed if, in fact, this property goes through. It's adjacent to my home. Again, that's the small, narrow strip of trees that they plan to put 210 cars in.
That's 09 Deer in Woods.
5 of them were there. This is my property.
010.
Can you hear the horn?
Where's that horn coming from?
That horn is coming from behind me, far away at the Ray Cattina showroom on Route 1. So again, you can understand how menacing it is to hear this all the time, especially if they're going to be just feet off of my property. I just can't imagine how this is going to impact our lives. It's very annoying. And it's old.
Okay, this is 011.
Same same picture?
Yes,
This is the same video we've already seen.
Oh, we saw this one already?
Yes,
saw this one.
this one too.
All right, I believe we've seen them all.
Okay, so just for the record, so we're clear, so far I have 1, 2, 3, 4, 5 videos, and the remaining 5 are pictures, correct?
Yes, there's a total of 10.
Okay.
Okay. What is the point you're trying to get across with showing these pictures?
That should this be further developed, you're looking at the ruination of a neighborhood. There are 6 of us that have purchased the houses that we grew up in on Old Post Road. We are not a coffee clutch community, but we stand united in the fact that this will be life-changing. If I can just ask the board, when we went to our last board meeting, not in January, but the one before that, where the last board met with us, they admitted that they didn't know that there were houses in this area, which was really disconcerting given the fact that they had sat for the term that they had sat. And Old Post Road is clearly such a busy road. So if I can just ask, before you move forward on any of your decisions, if you'll please go to that area and look at what exists there. It's a community. A showroom, further development by Mr. Catina's corporation just doesn't fit. He owns 18 dealerships in the state of New Jersey alone. 50% of them, according to his GM, are being enhanced at this time.
I just have 2 more questions for you. I'm assuming that the pictures you're showing of the traffic along Old Post Road is because you're concerned about putting more traffic on Old Post Road?
Absolutely.
And bringing cars and trucks in and out of this property?
Absolutely. Noise, pollution, speed. This environment has totally changed. When Mr. Catina initially developed his showroom on Old Post Road, there was a promise that he would buffer the back. And in fact, it was started, and there is a picture there that shows he began some sort of a retention wall and never put the trees there. So while they can say that they've been decent neighbors, I would oppose that. And I don't think there's a person in this building that would want a parking lot next to them. And I'm just asking that this be considered. I don't know, obviously Mr. Catina's corporation has been very successful. It leads me scratching my head. Why would somebody spend $660,000 on a piece of property they were not guaranteed to use? Thank you.
Thank you.
All right, ma'am, I'm sorry, if you could just say, just because you are, Mr. Licata is allowed cross-examination.
I
Wait,
don't
hang
have-
on, before we do it. Mr. Schwartz, are you completed with your turn?
Yes.
Okay, all right, Mr. Licata?
Thank you, Mr. Chair. I have no questions for Ms. Bruguera.
All right, ma'am, thank you so much.
Thank you.
Mr. Schwartz?
All right, so I'll put these, not me, but the person in my office who did this in the first place will put on a thumb drive. I think that would be probably the easiest way.
I thought you were going to do it. You seemed like a technical pro there.
What possibly caused you to get to that conclusion?
It's late. You can continue, Mr. Schwartz. If you have anyone else?
Yes, we have a planner.
If you, microphone, sorry.
Yes, we have a professional planner, Michael Pesolone.
Okay.
Pesolano, I'm sorry. I've only known you for, 20 years.
Sir, would you raise your right hand?
Am I audible?
Yes. Do you solemnly swear or affirm to tell the whole truth, nothing but the truth to help you God?
I do.
And please state your full name for the record.
Gladly. I'm Michael J. Pesolano. That's spelled P-E-S-S-O-L-A-N-O. Licensed professional planner in the state of New Jersey. Business address 140 Elmwood Avenue, Bogota, New Jersey.
And sir, just if you just provide your qualifications.
Yes, originally licensed as a professional planner in the state of New Jersey in 1984. I've been practicing municipal planning at the municipal level. One of my core competencies is plan review, detail-oriented kind of guy. You'll hear about that more later, but served as municipal in-house planner, served as consulting planner to a variety of municipalities as their board planner throughout northern New Jersey, and now more recently appearing before boards such as this for testimony on development applications.
And your license are current and in good standing?
It is.
Great. Thank
Still
you so
in
much.
good standing. I'm also a member of the American Institute of Certified Planners.
Great. Thank you. Counsel, you may
You're
proceed.
welcome.
Thank you. Accept him as an expert?
Yes, you're accepted.
Thank you. Mr. Pesolano, just to move along the testimony, have you done a study of the property, the master plan, the zoning ordinance, and the environs of the property?
I have.
And are you prepared to testify with regard to this application and render an opinion as to whether it satisfies the statutory criteria for a use variance?
Yes, I was also at the January 24th hearing on this application in full.
Okay, would you please explain the study you've done and provide your findings and conclusions?
Thank you. I will try to be as expeditious as possible. I understand the hour is late. Is there going to be a stop point that catches me by surprise, Mr. Chairman?
Once you, sorry, breaking my own rule. Once you start, we're going to allow you to proceed, and then we'll allow for the applicant to cross.
Okay,
Thank you.
great. Thank you.
Absolutely. And Mr. Schwartz, just if you just bring the microphone, I broke the rules, so you got to just bring your microphone a little closer, just while you're
Everybody
questioning.
makes mistakes.
Oh, I
okay?
know. I know. Yeah.
Okay, part of what I do with an application for any purpose, whether it's to advance the application or to object to it, I do a fair amount of objection work, fair amount of applicant work, just so you know. But the drill is the same. It is to really understand the plan, what the moving parts are, what is proposed in the application, what the applicable regulations are, the setting, the properties involved in the application and those around it, access, et cetera. I also familiarize myself with the applicable zoning and also the master plan for the community, in addition to looking at the site. I walked it extensively, photographed it myself, got a nice picture of a 9-point buck who just posed very nicely for me on Ms. Perguire's property, or on the land adjacent to Ms. Perguire's property, excuse me. Anyway, several things jumped out at me as factual matters that puzzled me, and I want the board to hear them for the benefit of this record. Please bear with me. When I review a plan, I look at every aspect of the plan where the development is proposed. And in doing that, the extent of development for this application includes lot 48.01 in block 266. That is the senior center property proper, generally to the northeast of the subject property. And the development spreads onto that parcel to get to the edge of the stream with the drainage outfall structure. The subject property does not go all the way up to the stream, and this would be at the northern end of Mr. Szilagyi's property, where the drainage outfall structure is proposed. So I was puzzled that that land on which development is proposed was not included in the land for development in this application, when clearly it is, in my opinion. All of this is my opinion, my findings. Other lands involved in the application include lot 37.01, block 266. This is the PSE&G power line lot. Interestingly, in the 2019 tax map, the words PSE&G ROW appear on the tax map and several parcel numbers in this same stretch that runs behind the subject property all the way down to Old Post Road on tax map sheet 55. The 2021 version of the tax map now shows that same land as a single tax lot. So I took it upon myself to look up the ownership, and it is indeed owned by Public Service Electric and Gas Corporation. Since this land is critical to the application having legitimate access somewhere, I found it odd that it was not included in the development application itself. Never have I seen, in fact, a situation where access is not identified to access, usable access to a public road is not identified. This is one such parcel, the adjacent parcel to the subject property at 604 Old Post Road. In addition, that power line lot is not adjacent to a public road, so access is further required through unspecified properties north of that between the power line and Route 1, presumably the Katina dealerships along that stretch of land. I noticed that in the notice for the January 24th hearing, it mentioned for access through dealerships, plural, to get to this storage lot over the PSE&G lot. So as a planner, it raises questions, that configuration. How do the vehicles come and go over that lot? Were the lots that this new traffic will pass through developed with that in mind? I'm not sure. It was not covered at all in what I heard of the application, but I think it's germane completely to two questions of particular suitability and substantial detriment. I don't know how the board can find those conclusions without knowing more about the nature of the access, the true access that is said to be coming from Route 1 through the nearby properties I just described. So with that, I want to observe that one of the principal purposes of site plan review in my practice is to enable evaluation of the safety and efficacy of vehicular circulation throughout a site. In the current condition, there is no driveway connection between the subject lots at 604 and 610 Old Post Road and the PSE&G lot. No physical driveway. It's all wooded by my own observation. And that is shown in applicant's exhibit A1, which was offered at a prior meeting. It's an aerial showing the land as it's configured with lot lines superimposed. The farthest extent that showing access got to in the application, as far as I'm aware, is a 24-foot wide or 18-foot wide driveway, whatever it's going to be, tangent to the PSE&G property. Where it goes from there or how traffic comes from any point beyond that is not identified in testimony or plans, as far as I'm aware. And I think it should be. So again, for stenographer's purposes and the record moving forward, let me just reiterate the block and the lot numbers associated with the lands that I think belong as part of this application. This would be 604 Old Post Road, also known as Lot 48.02 in Block 266, and Lot 3.01, which is known as 610 Old Post Road, Block 3.01, also lies in Block 266. And further muddying the waters for identification purposes is a recent conversion of merging of the two lots into a single tax lot as shown on the cover sheet of the site plan set, calling the two lots simply lot 3.03 in block 266. But as you heard, the discussion has been on the two lots as shown on the tax map, and the public notice addresses it that way too. Second lot that should be involved for the access purposes to be clarified is the Katina dealership on Route 1 that's most adjacent. Perhaps others along Route 1 that will be utilizing the power line approach to access this lot on the subject property on a regular basis. But the Katina dealership directly north of the access point that's shown on the plan is in block 198, lot 25.1. The PSE&G lot itself, again, lot 37.01, block 266. And finally, the Atlantic housing on lot 48.01, block 266. That's where the drainage structure outfall is proposed. So in other factual issues that came to my attention, the tax map shown on sheet 1 of the site plan seems to be a hybrid of factual information. I did drill down quite extensively to understand what the tax map representations mean. This is a convoluted kind of application because it relies on things that are adjacent to it and not clearly defined or expressed. So I took the liberty of drilling down to understand for myself so I could evaluate this in the best manner I could. But the tax map shows the PSE&G land as a right-of-way, yet it shows the division of 604 and 610 Old Post Road that was fashioned in 2020 as new lots that were not on the 2019 version of the on the tax map. So, in other words, the Atlantic housing property straddled the brook and came all the way down to Old Post Road at number 604. It was divided off, it was subdivided so that lot 48.02 would become the Katina property that we're considering tonight. So what I'm saying is there seems to be a hybrid tax map version on the site plan. I don't quite understand why one or the other wasn't used, but that'll be for the applicant to explain. More troubling than those things, the site plan cover sheet also has a little snippet from the zoning map for the township of Edison, showing the zone boundary line. As I see that line, it runs down the middle of the PSE&G lot. The site plan on page 3 asserts that the boundary line for the G-BH district is actually at the northern edge of lot 48.02, which is also 604 Old Post Road. The significance of that variation in factual information is huge because it is showing that the subject property that at 604 and 610 are not adjacent to the G-BH district at all. There's, as I would call a 50-foot gap between that zone boundary line and the subject property, and it's zoned LR, which is also a multifamily residential district. So any representation, the conclusion there is any representation that the subject property is adjacent to commercial property is misinformed. The center line of the PSE&G lot is demonstrated on the tax map itself, does not abut either side of that lot. It's down the middle, in my interpretation. I would like to then, and I'm sure you'll be pleased to hear me say, I'll move on to my actual planning testimony that addresses the positive and negative criteria, as I see it in this application, relative to the Medici analysis. It was correctly represented by the applicant's planner that this application in its entirety requires a D1 use variance because it's for a use not permitted in the district. The importance of that is that the application has to be scrubbed clean of any prior utilization for the proposed use that's on the ground today. That, as Mr. Schwartz's cross-examination questions revealed, there is no record, no standing claim, nothing about the car storage operation that currently exists at 610 Old Post Road that has been validated by the township in any by any land use board. So we start essentially with a 3-acre site that on which is proposed a car storage facility, a vehicle inventory facility that is situated in a residential zone in its entirety, not adjacent to a commercial zone. The contiguousness to the commercial zone is relevant because the ordinance, the zoning ordinance for Edison Township and the RB district cites allowance for conditional use of up to 100 feet behind a commercial use for off-street parking to be utilized as a conditional use. This application clearly does not meet the criteria. The applicant did not assert it was entitled to that conditional use. I'm just saying that this is a proposed non-permitted use floating in a residential zone, not tangent, not connected to any commercial use in any physical way. I'm sorry, not connected to a commercial zone in any physical way. The Medici analysis, I'm sure you've heard many times, is a 4-part evaluation. One addresses particular suitability, what's particularly suitable about the site itself that would make it particularly suited for this use. Second is a review of special reasons that would support the grant of a use variance, and those typically derive from the purposes of zoning expressed in municipal land use law. Part 3 is to evaluate is there a substantial detriment to the public good, which is also called the surrounding neighborhood. In many discussions, but they're the same thing, the public good and the surrounding neighborhood in this context. Finally, is the expected impact impairment. Is there a substantial impairment to the intent and purpose of the zone plan for the municipality if this application were granted? So with that introduction, I briefly will touch on these points. Regarding the particular suitability evaluation, I firmly believe that the site is particularly unsuitable for the proposed development and utilization that's before the board in this application. This is squarely within a residential neighborhood. The property is surrounded on 3 sides significantly by residential uses. There are some non-residential uses on the ground, albeit, but the takeaway for me is that this site is surrounded by residential uses. And as a planner, I have to say that residential uses must be afforded the greatest protection. The governing body of Edison Township happens to agree because the planning policy points to protection of residential neighborhoods just like this. There's nothing special about this neighborhood that doesn't warrant the fullest protection that planning and zoning can give residential neighborhoods. In the master plan, that was a reexamination report of 2011. That was reemphasized as a top objective, is to prevent the intrusion of incongruous uses into existing residential neighborhoods. This application would do the opposite. It would foist a very large 3-acre new use into a residential setting, which is harmful to the ongoing health of that residential neighborhood by virtue of substituting residential for a car parking facility when the zone plan calls for all residential here. The site access is anything but appropriate for commercial land use, let alone particularly suitable access. There's a pledged limitation on access onto Old Post Road to keep that an emergency access, which means that the only other access is to be through 2 other properties from Route 1 in some yet undisclosed way. That, to me, says that this application is not ripe for action because that important part has not been disclosed about how traffic gets in and out of the subject property if it's prohibited from coming and going from to and from Old Post Road. The other problem with the access and the relative suitability of the site is that what is proposed is access through a power line property via an agreement of questionable duration. You heard testimony and cross-examination questions from Mr. Schwartz that covered that, so I'm not going to reiterate that. But that is indeed the concern. Effectively, in 60 days, that access could disappear. And what happens if a going operation is suddenly robbed of its access? There may be actions to address that we don't want to consider because that's not what the application presented to this board was about, to have the different means of access. As I took notes during the planning testimony in January of this year, I did indeed hear that there was existing automobile parking on the ground today on 610 Old Post Road. And as I reviewed the section on non-conforming uses of the township's code, township zoning ordinance, section 37-66.1, which speaks to the intent for non-conforming uses, there is no basis allowed for building on an existing use on the ground to justify a new non-permitted use. So I think that's an inappropriate characterization that this is adding to what is already there. And as I said earlier, that should be disregarded, for it is not a legitimate use on the ground today. The applicant's testimony at the through various witnesses at the hearing on January 24th that I witnessed attempted to make the claim that this is not a high quality RB neighborhood and somehow inferring that putting another non-permitted use here would not be terribly impactful. I think that is misinformed completely. Somehow it escapes me that the logic of multiple wrongs will somehow make a right out of that. that we're talking about a proposed conversion of 3 acres of land to non-residential use in a zone where the minimum lot size is 7,500 square feet for permitted use. And indeed, by observation, doesn't take a trained eye to see, just looking at the tax map of the parcels around this property, they're dwarfed by the size of the subject property that is proposed for a non-permitted use, which to me represents a game-changing element, pulling the rug basically out from all the residents who've paid taxes over decades and decades, expecting to have a residential experience. Now that's quite threatened by this application, and it is quite avoidable that their expectation for ongoing use of their residential property be hindered by not approving the application. Of particular merit regarding planning and zoning, the 2011 reexamination report, master plan, specifically mentioned that one of the reasons to revisit the RB zoning bulk standards was to take away disincentives for homeowners in the RB zone to invest in their property. If, as you know, if reinvestment doesn't happen through owners of the property, decay happens. And so if this development proposal is approved, it signals very loudly to the residents in the surrounding community, look what's become of your neighborhood, a great disincentive to even think about investing further in that location. To me, the next logical result of that outcome is disinvestment on a large scale, conditions of blight, crime, you name it, the things that move in when an area goes into sharp decline. I think this project would be a catalyst towards the decline end of the scale rather than a neighborhood enhancement. What is particularly striking about this land that's said to be particularly suitable in the application is that it effectively proposes to create a through lot for commercial purposes from Route 1 all the way to Old Post Road. Effectively create such a through lot. That's roughly 950 feet of depth from the edge of Route 1 and poking deeply some 700 plus feet into an established residential neighborhood. I truly searched and did not find any guidance in the master plan or zoning ordinance to encourage that kind of action on behalf of any property owner. So it's an intention to create a very unusual situation that probably would not even come out of a planning process, given the circumstances about the use and the unsuitability of Old Post Road to accommodate any additional commercial utilization. It was mentioned that the property would, or the use itself would be screened behind vegetation, fencing, drainage improvements would be added to the site, lighting, plantings. But none of those things contribute to a site being particularly suitable for the non-permitted use that's intended. It is, in my estimation, merely convenient for the Catena organization to handle its business for itself. I can find no basis for the public welfare being promoted by this use at this site, promotion of the general welfare is essential for use variance applications in my experience and in the case law. And if the use is really not advancing the public good, the surrounding public uh, lands owned by citizens, it's really not rising to the level of promoting the general welfare. And that is the basic criteria for the board to find particular suitability in this part of the Medici analysis, that because the site is so particularly fitted to its location, it advances the general welfare. For the reasons I've stated, it does anything but advance the general welfare. It pledges to wreak havoc with an established residential neighborhood, in my professional opinion. The upshot of my analysis is a general finding that conversion of these 3 acres to non-residential use right here is extremely hostile to the planning and zoning process decreed by the New Jersey legislature and echoed in the Medici case, that planning and zoning should take place by ordinance and not by variance. Because we have a proposal for a 210-car parking lot poking 700 plus feet into an established residential area, destabilizing the residential area, I find no basis for that to warrant a variance, let alone a zone change. We're not talking about a zone change here. That can only be done by the governing body, as you know. But clearly, this ill-conceived application effectively seeks to zone by variance rather than by ordinance, in my opinion. So on the basis of what I've explained to you in the particular suitability part, I find that the application clearly fails to satisfy the particular suitability element of the Medici analysis. Step 1, not met. Step 2 is to evaluate special reasons. As I heard,
Mr. Pistolano,
yes.
I'm sorry, I'm going to break in. It's the hour's getting late, and so I'm going to ask if you can. I know you want to do special reasons and you want to do negative criteria. If you could kind of try to summarize as best you can.
I appreciate that nudge, and I understand why, so I will do my best. I don't find that any of the special reasons that were cited in the planning testimony in favor of this application would be particularly appreciably better than the special reasons that would also accrue to conforming development on this same land. I just don't see any basis for a conclusion that special reasons exist for this application. It's my opinion and a general expression of it here that not only doesn't it promote purposes of zoning, as expressed in the municipal land use law, it's actually hostile to good planning and zoning. In particular, and this is the only one I'm going to touch on in detail. There are many special reasons that I find are compromised, but the one that jumps out at me is purpose B, which is to secure safety from fire, flood, panic, and other natural and man-made disasters. That's a big one. That's what boards exist for, to make sure we don't make mistakes as we accommodate development and redevelopment of land. That's what site plan review is all about, is to cover those points. I think this proposal would sharply contravene this purpose by placing substantial and abundant unmonitored sources of highly volatile combustibles within close proximity of occupied residential uses. I'm talking about the quantity of cars proposed to be parked within proximity to occupied residential property. In addition, the excess impervious coverage near flood-prone area creates potential for increased flooding should the proposed stormwater facilities fail. Both of these life safety threats can be reduced or avoided by adhering to existing development regulations, in my opinion. Because of the impacts that are looming for adjoining residential properties and the neighborhood itself, I find that the application fails to satisfy the public detriment criteria. There would indeed be substantial detriment to the public good for the reasons that exist on the record from my mouth and those before me. There is nothing about this use that promotes anything in the form of a desirable visual environment, landscape it, fence it, if you will. It's still a 3-acre parking lot and will be noticed and known for that, no matter what is done to it, in my opinion. As to the fourth prong, part of the Medici analysis, substantial impairment to the zone plan and zoning ordinance. Oh, let me back up. 2 properties are particularly impacted with substantial detriment in this application, in my opinion. Mr. Szilagyi was eloquent in explaining his concerns. Ms. Bruguier also eloquent in explaining her situation. I think it's really quite astounding that a property boundary of some 526 feet along the side and another 100 feet to the rear would be exposed to nothing but a parking lot. And this is a longstanding residential good neighbor property in the township. Why does that property owner deserve that kind of treatment? I don't think they do, nor does Mr. Szilagyi. As there's no stated policy in the master plan, nor any zoning provision to authorize this type of massive conversion of land from one use to another, from a permitted use situation to non-permitted use, it is an underscoring of the idea that this is impactful and it poses a substantial impairment to the intent and purpose of the zone plan and zoning ordinance for the township. So in conclusion, based on the failure to meet all 4 of the criteria for the Medici analysis, this application has not earned approval of this board. All 4 elements have to be met, not just one. So it fails all 4, and I think there can be no conclusion but to reject this application, and I urge you to do so. I stand ready for your questions. Thank you.
Thank you very much. Does the board have any questions? Okay. All right. Ms. Licata, given the hour, and Mr. Schwartz, given the hour, I know that you want to cross of the witness. I think we should hold that off for another night. Mr. Schwartz, just for a matter of housekeeping, beyond the witness, how much further do you have on your
That would
case?
be my case, and obviously I'd like to summarize.
Okay, all right, and then, okay, so just for a matter of housekeeping, so we will find a date for a continuation. Mr. Licata will cross-examine, Mr. Schwartz will then wrap, and then for the public here, we'll go back out to the public, within 200 feet, then outside 200 feet, and we should be good to go. Madam Secretary, if we have any dates available? Mr. Dave.
There are a lot of genuine concern raised tonight, and I just want to make sure the applicant, when they come back, maybe consider some of the proposed solution. One thing that maybe they can increase the density buffer by removing the trees and planting more toward the four side of the borders. So at least you have thicker buffers, and that would control the noise pollution, the light pollution, maybe the air and smoke pollution to the neighboring properties. You can also consider the condensed parking probably, and I understand that that may not be efficient, but that you can achieve it by without losing your parking spot and giving them the dense buffers. There's also the genuine concern about the beeping noise when they come to pick up the parked car. This is being an inventory lot, so maybe you can have some kind of ID system at every parking spot so they can identify where the car is parked, and they don't have to put the alarm on and beep, 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 and that was genuine concern for the neighbors. And there's also a concern raised about right-to-way for PSCNG access from the rear end of the property. And as I understand that PSCNG can terminate that within 10 days or 60 days. What did I hear?
60.
60. So if they decide to terminate, and it's not a hypothetical question, it can be probability that they can. If it didn't happen 30 years, doesn't mean it cannot happen. So what happens to this parking lot? This becomes the dead inventory parking lot at that point. So if this board considers any kind of approval, if you lose that right of way from the back of the existing property, you will come back to this board within 30 days and not start automatically using the access from the old post road, right? So I just wanted to make sure that they come back with some kind of proposed solution for the next meeting.
All right, Mr.
Chairman?
Wait, no, we're not. Wait. Madam Secretary.
The next date we have is May 30th, if that's good.
Wait, Cassandra, was it May or June? I'm sorry.
May 30th.
May 30th.
Is that the day after Memorial Day weekend? That could present a problem if people go away for the weekend. If that is Memorial Day weekend.
If not, we could do June 20th.
It's not Memorial Day weekend, and I think
No,
we can
it's
do
not.
May 30th. So you want to do May 30th? So I'm sorry, May 30th works or no? No, you don't want May 30th. You can't be here. Yeah, okay. So June? Yeah.
June 20th?
June 20th works. Does that work for us? Bill?
Mr. Schwartz?
I'm fine.
Okay. All right. So this hearing will proceed on June 20th. There will be no further notice. This is your notice for anyone here and for anyone listening at home. This hearing will continue on June 20th. With that.
So you'll obviously want Mr. Pesolano back.
Yeah, absolutely.
Oh, absolutely.
Okay.
Mr. Chairman?
Vice Chairman?
Just expand on Mr. DeVenger said. All right, make a motion to close.
Motion to adjourn. Seconded by Mr. Sadata. All in favor signify by saying aye.
Aye.
Opposed, nay. The ayes have it. We stand adjourned.
Thank you.